For judgment, PIL 86/21.
We have closed the PIL saying that it is premature and material facts are not there. But the copy of the FIR, etc., which is legally permissible, if the petitioner applies for accordance with law, it should be given to him.
I agree.
Item 2 and 3, criminal appeal 18/21.
Both the appeal succeeds. Both the appellants are acquitted on benefit of doubt.
DPC has already been held. Lordship has restrained the DPC to hold the DPC, Lordship, considering the
Which matter, which case?
Lordship, this is regarding promotion to the post of civil engineer in
Ah.
Water Resources Department. And Lordship has last occasion on the 25th. Lordship has passed an interim order. It's not uploaded. We came to know yesterday evening, Lordship. So I am going to return on 31st, Lordship. I have already informed the other side also. Obliges.
Yes, Lordship granted permission for listing this matter, my lord. Therefore, yesterday I made a mention, my lord. For today, your Lordship granted permission, but matter has not been listed. Can we take on one day, my lord?
Lordship, claim for listing this matter on admission for admission on Monday, Lordship.
Why Monday? Why not Wednesday?
Yes, Lordship.
After 2 weeks. All admissions after 2 weeks.
2 weeks, Lordship.
No, sorry, then it is rejected. Take it as rejected. If you can wait for 2 weeks, fine. Otherwise, it is rejected. Admission matters pending for so long. You want it immediately on Monday, Wednesday. What are these promotion cases?
No, Lordship, non-payment of area salary are not providing revised grade pay, Lordship.
All right, we'll consider it. But why on Monday? What is the tearing hurry in these matters?
That is.
After a week. After a week.
After it. Next Monday.
Mm.
May I plead the Lordship? Also, this is 2015 and 16 matter, Lordship. This may also be listed next.
After 2 weeks. Yes.
Wait, Your Lordship. Lordship, I beg to mention item number 28 to 32, Your Lordship. Lordship, may kindly adjourn the matter for the Your Lordship.
28 to
32, Your Lordship.
You are appearing for whom?
For the petitioners, Your Lordship, in all the cases. Your Lordship.
You have informed the other side.
Lordship, I informed our standing council of PNRD.
There is any interim order
Lordship, no.
with the consent of the learned departmental counsel, Mr. N. Gautam,
Lordship.
learned counsel for the writ petitioner in this batch of petitions, has prayed for adjournment in these cases with a request to list these matters again after
A week, Your Lordship.
2 weeks. Full stop. Since the prayer is not opposed, same stands allowed. These matters stand adjourned for 2 weeks.
Lordship.
28 to 31.
32, Your Lordship.
Actually. 32 is also there.
Lordship.
28 to 32. Yes.
May I please, Your Lordship, my prayer is for listing ballot. It's a pension matter. The petitioner was retired in 2018. He is not get any provisional pension. The matter may be taken on next week, any date.
All right.
May please, Your Lordship. Lordship, with consent of the other side, Lordship, I beg even item number 23 of Lordship, daily list, Lordship. Okay, may I kindly for adjourn for the day, Lordship.
You are for petitioner.
Yes, Lordship.
On the request of learned counsel for the petitioner, this matter stands adjourned for 2 weeks. Yes.
May I please, Your Lordship? I beg to mention a WBC case for withdrawal.
When?
On one fifth. Of the statement.
Daily list for motion item 1.
Lordship, okay, in this case, earlier notice was issued, so it ought to have listed for admission, Lordship. And also extra copies has not, Lordship, served, therefore instruction could not be taken.
What is this matter about?
Lordship, this is regarding selection in the staff selection commission, SS CAPF, Central Armed Police Force. Lordship, these petitioners were not selected. They are ST candidates, but some candidates who scored lesser marks in general category, unreserved category were selected. And these persons, they have not taken any relaxation given to the SC/ST. Therefore, their cases should be considered as unreserved candidate. That has to be done in this case.
All right, you have not given extra copies.
This one I should give it to the Lordship. I
All right, I
will.
had a number you had so and so for the petitioner. Ms. R. Devi, learned CGC appearing for the respondent submit that notice has already been issued in this case and therefore the matter has been wrongly listed for motion today. The learned CGC, however, submits that due to want of extra copies, she could not obtain instruction in the matter. First, the petitioner's counsel has assured this court that extra copies, requisited numbers, will be furnished to the learned CGC within 3 days from today. In view of the above, let this matter be listed again for admission after 4 weeks. You are appearing for all the respondents, right?
All the rest.
Item 2.
My Lord, in the they are OBC candidates. Different number.
Same order.
Same order, man. I am appearing for all the respondents.
S. Sharma for all the respondents.
B. Sharma.
B. Sharma.
My Lord.
Same order.
Obliged.
Item 3.
But if the petitioner applied for the post of Anganwadi helper, your Lordship, the petitioner called for 5 of the interview. Some reason she was not exactly appeared.
Petitioner appeared when?
Yes, extra eligibility was filed. Lordship,
Appeared when?
when on 4th of August 2022. That is reflected in the affidavit dated.
Yes,
2nd of
Mr.
December.
Sutia.
My Lord, I will have to obtain instruction, my Lord, why he was not allowed. Only his grievance, that's what his grievance.
He or she?
She.
Heard Mr. R. Hazarika, learned counsel for the petitioner. The grievance of the petitioner is that despite being eligible, she was not allowed to participate in the selection process for appointment to the post of Anganwadi helper. Post of Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing for the respondents.
1 to 6.
Respondents 1 to 6 prays for some time to obtain instruction. They are allowed NOM 4 weeks. Since Mr. Chutia has accepted notice for all the respondents, no formal notice, extra copies.
RP had it, not RP had it.
Item 4.
May I please, your Lord? Lordship, matter pertains to compassionate appointment, my Lord. What happened, my Lord, after demise of the father of the petitioner, my Lord? His mother has submitted an application for appointing him on behalf of his father. Thereafter, my Lord, his application is recommended and considered, my Lord, page 24. Thereafter, I call for the interview, my Lord, and document verification, my Lord. Page 24, where he is called for the document verification on the said post. As per the last order, my Lord, the respondent counsel has said, my Lord, this prayer is being considered and rejected, my Lord. Kindly peruse the order dated 2012-2022, my Lord.
Which page?
My Lord, the last order of this honorable court, my Lord. 2012-2022, my Lord.
What is the order passed?
My Lord, order is not passed, my Lord, only I call for the documents verification, my Lord. Order is about to provided by the respondent counsel today, my Lord.
Who's the counsel?
B. Chaudhary has appeared, my lord, on the
B.
last occasion.
Chaudhary, he is not there. You call him. You ask him to come.
My lord.
Item 5.
My pleasure, Lordship. My lord, the petitioner has filed an instant writ petition being aggrieved by the action of the respondent authorities, my lord, in awarding very less mark in the psychometric test held for filling of the post of constable in Assam Police, my lord. My lord, the entire test consisted of, my lord, 100 marks, my lord. 80 marks were from the physical efficiency test and 20 marks were from the psychometric test, my lord. Here, the my lord, all the petitioners have fared quite well in the, my lord, psychometric test, my lord. The results are at page 60 to 66, my lord. Most of them secured above 65%, my lord, in the physical efficiency test, my lord. And they have in fact fared quite well in the, my lord, psychometric test, my lord. But because of some discrimination, my lord, they were awarded very less marks, my lord. And in fact, my lord, in the psychometric test, my lord, there was no psychologist in the panel to held the test, my lord, which have been specifically mentioned in the minor petition, my lord.
Some other matter is already fixed after 2 weeks, is it? Assam Commando?
No, Lordship, that is all different matter. He is challenged the marks of obtained in the psychometric test. And in other matter, not, I forgot. I think not in related to this matter.
So when were the marks announced? Marks were announced when?
Of the psychometric test, my lord.
Yes.
No, I don't have the exact date, my lord, but the result is result sheet is page number 60, my lord.
What is your instruction? There is an order to seek instruction.
To seek instruction from the petitioner,
No, it was
Lordship,
from my side,
to
my lord.
assess how assess the psychometric test. It is this instruction
Just
from
from my side, my lord, on what material basis can be taken into account.
Yes, you have to give some basis
My
to
lord.
prima facie
My lord, I have
establish.
taken instruction from my client, my lord, as well. I have done some research in the internet, my lord. In the senior psychometric test, my lord, the psychometric test has generally helped to ascertain, my lord, the behavior, personality, and other abilities of the test of the candidate for the test job, my lord. But same are not
No,
connected.
Mr. Gohai, your
My-
RD
my-
Gohai, is
my
it?
lord.
See, in a court proceeding,
My lord.
when you are seeking to reopen a selection process or something like that, you have to give some materials for the court to be prima facie satisfied.
My lord.
Otherwise, everybody will come to the court and say that, I don't know, I've done well, so you find out what has happened.
My lord.
That approach cannot be adopted. That
Well-
is why the learned single judge had passed an order. You have to bring some materials on record.
My lord, I have done thorough research, my lord. But
Then we have to close the case.
my lord, in fact,
There maybe you are right, but then this is a court
Well,
proceeding.
in fact, my pay is very limited, my lord. My lord, I am not asking to reopen the entire selection process, my lord. My limited pay is that, my lord, a fresh this court, honorable court may direct.
So that is what you give us some basis to pass that order. Your saying will not do.
My lord.
If you don't have any basis, then you don't have a case.
And
As
then
simple
I have,
as that.
in fact, in my repetition, I have specifically stated, my lord, in the psychometric test,
Hmm.
and in fact, in the advertisement, my lord, it was not anywhere mentioned that a psychologist should be there, my lord. And as per my research, my lord, in a psychometric test, there should always be a professional psychologist. So to ascertain the personal behavior, ability, and
No,
attitude,
but everybody is subjected to same test.
my lord.
You can't choose.
My lord.
That's the law.
My lord.
Even if it is not,
My lord.
only ground of interference is this is discriminatory.
My lord.
Everybody has been subject to the same.
And in fact, my
criteria.
lord, the petitioner number 1 and petitioner number 7 had a EWS certificate prior to the last date fixed for submission of document, my lord. And in fact, the same was also not considered, which I have specifically stated in my writ petition, my lord.
Well, issue notice returnable in 6 weeks. That's all. Or Mr. R.B. Gohai, learned counsel for the petitioner, peruse the amendments made in the petition. The petitioner's grievance is that they were not awarded proper marks in the psychometric test, as a result of which their names did not find Final list published, select
My lord,
list.
only published, my
Yes,
lord.
yes.
Right. Final select list. Full stop.
Candidate candidates have also joined, my lord, in the
Hmm.
post, my lord.
It appears that appointment orders have also been issued and the candidates have also joined their post. Full stop. Be that as it may, considering the amendments made in the writ petition, I am inclined to examine the matter. NOM 6 weeks. This S. Borua, learned government advocate Assam, appears and accepts notice on behalf of all the respondents. So this matter should be closed, you know, this is creating problem.
My lord.
Uh,
Well, at least the government may file a reply, my lord.
No, but what can be done now? They have been appointed.
My lord, there is also, I have taken instruction, my lord, there is 311 posts are still vacant, my lord.
8 weeks, make it 8 weeks. If you have an accepted notice to the respondent. No formal notice is required to sign in this case. Extra copy will be furnished to the learned department counsel. No prayer for interim relief.
No, my lord.
Okay.
I love that.
Item 6.
May I please your lordship? Lordship, here in the grandfather of the petitioner was the Gaubura of Vera village. My lord. Thereafter, my lord, due to physical incapacity of the grandfather of the petitioner, my lord, the father of the petitioner has given the charge to do work on behalf of him. Thereafter, in the meantime, my lord, an advertisement was issued for the regular selection of the Gaubura, my lord. In that selection, my lord, the petitioner also participated, but his candidature was rejected, my lord. But in the select advertisement, my lord, page 18,
Candidature was rejected.
my lord,
Candidature rejected means he was not allowed to take part.
but my lord, I'm
Or
sorry,
he
my
was
lord,
not selected.
I'm not selected, my lord, I'm sorry.
So
I'm
it
not
can
selected,
happen.
my lord.
Hmm.
And page 18 clause 5 and 9, my lord, kindly pay those, my lord. Clause 5 it says the selected candidate should be from the Gaubura family, my lord. Who the person has selected, he is not from the Gaubura family. And 9, clause 9 of the advertisement, it says, my lord, the person should be involved in the social works and other activities in during his career, my lord, like natural calamities. Page 18, my lord, kindly peruse, my lord.
Hmm.
It is the advertisement. There are certain conditions has been made, my lord. Base clause 5, my lord, candidate belonging to the family of Gaura will be given preference as far as feasible. Petitioner is belonging to the family of the Gaura, my lord, here.
Hmm.
And clause 9, the candidate who have helped in the implementation of government policy as well as provided help and coordinate in times of natural calamities. As the father of the petitioner was in charge of the health Gaura of that village, my lord, during that period, my lord, petitioner also helped him, my lord. But he was not selected, my lord.
These are very weak type of case. Hmm. Ordinarily, these writ petitions should be dismissed in limine. But we'll dismiss it at the admission stage because that will give you some comfort. We are concerned about the comfort of the councils also. That is the only reason we'll dismiss it in admission, not in motion.
Even then, lordship, that there is a appellate provision, lordship. So 162C, my lord, the executive instruction on 10/4/2018 instruction, lordship. Within 60 days, they have to prefer an appeal before the commissioner, divisional commissioner. Lordship.
When was the private respondent appointed?
So already, my lord, that it was the circular was, my lord, published on, my lord.
My lord,
3/1/2022.
3/1/2023.
And in call for
There is time, my lord, he can prefer an appeal before the, my lord, the
So
commissioner.
why don't you prefer an appeal? You will get more facts.
my lord, then my lord,
On these facts, what can be done? Dismissal is the only answer.
if my lord record may be called for, my lord, then my lord.
No, question doesn't. We are thinking of whether to dismiss it today or on the next day. You're talking about record.
My lord,
These are
then,
not matters where writ jurisdiction should be exercised. You thought you should be selected. You have not been selected. So set aside his appointment. How can these things be done?
as my lord, the private respondent who has been selected, my lord, he has not the requisite qualification, my lord, for the advertisement. My
So
lord,
you
even-
want dismissal and admission. Heard Mr.
my lord, as Hazarika, my lord.
Yes, Hazarika, Learned Counsel for the petitioner, assailing the appointment of the private respondent, that is respondent number 5, as Gaugura of
My lord, charge number 17 of 4 number Vera village, my lord.
charge number 17 Jania Moza under Bagbar Revenue Circle. The instant lead petition has been filed. Inter alia contending that the respondent number 5 did not meet the qualification norms as prescribed by the authorities at the time of selection of candidates. First of, on the contrary, the petitioner being a member of a Gaugura family and having participated as a Gaugura on earlier occasions was more deserving and eligible for being appointed as a Gaugura. Full stop. Mr. J. Hendik, Learned Standing Council, Revenue and Disaster Management Department, Assam, has questioned the maintainability of the writ petition on the plea of alternative remedy and submits that the writ petition is devoid of any merit. Full stop. Similar is the stand of Mr. J.K. Parajali, Learned Government Advocate, Assam, Vacating for this case. Be that as it may, taking note of the amendments made in the writ petition, I am of the view that notice is required to be issued in this case. First of NOM 8 weeks, since Mr. Hendik has accepted notice for respondent number 1 and Mr. Parajali for respondent numbers 2, 3, and 4. No formal notice is required to be sent to the respondent numbers 1 to 4. However, extra copies, in requisite numbers, be furnished to the learned departmental council so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 5 by registered post with AD within a week from today. Question of
Our name not shown in the.
Question of maintainability of the writ petition is kept open and will be drawn into at this stage of admission hearing. Register to list this case by reflecting the name of learned departmental council.
Claim number 9 is also similar, my lord. Only village is different. My lord.
What is the name of the village?
My lord, Kisamat under Donia Moza, my lord.
He's under age is admitted. His age should be not less than 30 years. His age is 28 years. That's why his case is different. But if kindly see.
Then we'll take up the matter when it comes. Yes. Let it come.
He did not serve the copy to us, my lord, in the item number 6 and also 9.
You are not eligible.
No, my lord.
All right, you wait.
My lord.
This one will be today. You wait. Yes.
I am appealing for my lord. Oh.
Yes, what is this?
Lordship, petitioner before your lordship is the copyist. Actually working under the establishment of the respondent number 3. She is the senior most lordship copyist, and while the promotion was considered, her case was not considered by the lordship authority. Rather, juniors were promoted. Limited grievance lordship before this honorable court. Lordship direction may be given to consider the seniority lordship for making promotion in the lordship. She was working for last 30 years. And she the lordship kindly have a look at the graduation list, page 19, annexure 9.
So we have to issue notice, no? There is a private respondent.
No, there is no private party. We are not challenging their appointment. At this stage, we are not.
No, you are seeking promotion.
Lordship.
So somebody has been promoted. Which post you are seeking promotion?
Lordship for the post of UDA.
UDA post is held by someone.
Lordship.
So how can you be promoted?
So lordship, if there is a vacancy arise, in that event, my case may be considered. Otherwise, I am senior most. My juniors are considered. I was not considered.
All right, I heard Mr. L.R. Majumdar, learned counsel for the petitioner. The writ petitioner hearing is serving as a copyist. You're serving as a copyist in the establishment of Chief Judicial Magistrate Silchar. According to the petitioner, she is the senior most candidate in the cadre of
Lordship LDA
oblique
copyist and computer type.
Oblique computer LDA oblique copyist oblique computer typist, but not full stop. Notwithstanding the same, her juniors have been promoted to the rank of UDA. Full stop. Mr. L.R. Majumdar submits that although he is not client, his client is not challenging the promotion, public appointment in the post of UDA in respect of any other candidates, her simple prayer is that she should be considered against the next available vacancy. She should be considered for promotion against the next available vacancy in the rank of UDA, full stop. Mr. H. Das, Learned Standing Council, Guwahati High Court. H.K. Das, Standing Council, Guwahati High Court, and Ms. S. Burwa, Learned Government Advocate Assam, pray for some time to obtain instruction in the matter. NOM 6 weeks since Ms. Burwa has accepted notice for respond number 1 and Mr. Das for respond numbers 2 and 3. No formal notice is required to be sent in this case. Extra copies of the requisition be furnished to the Learned Department Council so as to enable them to obtain instruction. The registry to list this case again by reflecting the name of Learned Council for all the respondents in the cause list.
Like,
It is made clear that pendency of this writ petition shall not be a bar for the authorities to consider the case of the petitioner in accordance with law, if so advised.
Well, in this case, my lord, if a petitioner, my lord, if being aggrieved to my lord, being refused to participate in the selection process for the post of the chief administrative officer of district and session judge, my lord. By which, my lord, the first instance, my lord, the one advertisement was there. Then nobody was found eligible. Then the second advertisement came. And the second advertisement, my lord, he applied, but his application was rejected on the ground that he has not had the qualification as per the my lord, rules, my lord, 87. And the second, my lord, on filing the appeal before the High Court, that is also rejected. But my case is this, my lord, the draft rule has come into, my lord, been adopted by the Honorable High Court in process of the Honorable High Supreme Court decision of a Renu versus, my lord, the accusatory court case, my lord, to review the entire matter and if necessity to combine the all the my rules for recruitment of the my lord, employees of the lower judiciary. So as per that rule, the chief administrative earlier post of the solicitor had been redesignated as a chief administrative officer of the district and session judge. And by his melody, the criteria is that the candidate who are having the qualification of graduate minimum and 3 years in the post of the administrative officer in the district, additional district and session judge and district judge, as well as the CGM, my lord. They may apply, but that so far that recruitment condition is as mentioned in the rule 4, well, schedule B(a)(1) and the schedule B of the rule 4. That was not compliant. But interestingly, my lord, by a notification, the redesignation post of the chief administrative officer with the pay scale has been given the benefits. But so far the recruitment and the qualification is concerned, it is not followed. That is my case, my lord. So the private respondent, in spite of having no qualification to graduate, he is not a graduate, undergraduate, and he is having the only experience of 1 year, 4 months. Contrary to 3 years and the graduate is a compulsory.
Where is the order by which High Court has rejected?
Yes, my lord. The annexure 8 at is 57, my lord. 51, my lord. Sorry, my lord.
Prior to that, there is another order, page 43.
Yes, sir. That is there. But this order, without showing any reasons and other thing, only mechanically there's a order has been passed that the application has been rejected. And so far, my lord, this draft rule is concerned, my lord, in absence of the rules, my lord, the draft is very much applicable. Once the one part of the draft rule is accepted, then the other has to be followed. And the so far, my lord, the clearance of the this High Court for sending for notification.
So now it is about promotion to the post of Chief Administrative Officer. The establishment of district and sessions at Jorhat. What has happened? Who is holding this post?
Now is a respondent number 6 being my lord selected, and it is not a petitioner, my lord, at the time of filing the my lord petition. Is only my lord one my lord online copy here, my lord procured, but there is no specific date. As per that notification, my lord, he has been promoted to the post of the chief administrative officer, but the date of my lord this is not there. I am not able to procure the copy in spite of my filing the RTI application also.
So then we have to issue notice, and his promotion will be subject to further orders.
Only one aspect of the matter, my lord. So far as the
No, but what is this? Without any reason, his representation.
that's true. But page 43, my lord, will kindly have
What
a
kind
look.
of an order is passed by the High Court?
Page 43, my lord, have a look, my lord.
This 42 is earlier, my lord, this is I on against the
Initially,
time.
it was rejected by the
Yes, my lord.
district and session judge Jorhat.
Just a minute, let him say, you have made your submission,
yes, my
please
lord.
take your seat now.
Yes,
Yes.
This was the order initially passed, thereafter he again submitted a representation and the Honorable High Court, the registry of this honorable as the order. And these two orders are not challenged in the present writ petition, that is number one. Upon the respondent number 6, he has been appointed. His appointment order is also not challenged in the instant writ petition.
All right, we'll have to issue notice at this stage.
And so far as, my lord, implementation of draft rule is concerned, only in respect of process server, there was a decision by this registry of this honorable court to implement a particular provision of the draft rule. So not for the other category of.
All right, heard Mr. P.
My lord,
Mohan,
one
Learned
thing,
Counsel.
one thing, my lord, they, as per my learned friend said, I am not challenging the, my lord, both the, my lord, decision. I have challenged and moreover, my lord, at the time of the filing, this, my lord, this was not specifically, I am getting the copy of the, my lord, appointment order. So that is why, my lord, I specifically mentioned this, that is why I am challenging this appointment also, because there is no, my lord, copy on my, in my hand at that time. Even today also, I am not having it.
All right. Heard Mr. P. Mohan, Learned Counsel for the petitioner. The lead petitioner hearing is serving as head assistant in the establishment of Chief Judicial Magistrate Jorhat. He had applied for appointment or promotion.
My lord, this is a appointment as well as promotion, my lord, because this is a by way of promotion.
Appointment stroke promotion to the post of Chief Administrative Officer in the establishment of District and Session Judge Jorhat. However, the candidature of the petitioner was not considered on the ground that he is not eligible to apply for the post. Consequently, the respondent number 6 was selected for appointment to the aforesaid post. Mr. Mohanta submits that although no order of appointment of respondent number 6 is available in public domain, yet he has assailed the selection and appointment, if any, made in favor of the respondent number 6 in the post of Chief Administrative Officer on the grounds mentioned in the writ petition. It is also the submission of Mr. Mohanta that as per the draft rule, which is being implemented by the authorities, the petitioner was eligible for being considered for the aforesaid post. Notwithstanding the same, his case has been arbitrarily rejected. Mr. H.K. Das, Learned Standing Counsel, GHC, Guwahati High Court, prays for some time to obtain instruction and file affidavit. Prayer allowed. Issue notice of motion returnable on 27th of February 2023. Since Mr. Das has appeared and accepted notice on behalf of respondent numbers 1 to 5, is it?
2, 3, 4, and 5.
2, 3, 4, and 5, and Ms. S. Burwal, Learned Government Advocate also. For respondent number 1, service of notice is deemed to be complete. So in respect of, make the notice returnable on 1st of March, 1-3. In respect of respondent numbers 1 to 5, extra copies, requisite in numbers, be furnished to the Learned Departmental Council so as to enable them to obtain instruction and file affidavit. Petitioner to take steps for service of notice upon respondent number 6 by register post with AD within a week from today. Let this matter be listed by reflecting the name of Learned Counsel for the respondents in the cause list. It is made clear that the order of appointment, if any, issued in favor of respondent number 6 shall be subject to further orders that may be passed in this proceeding.
Deeply okay. May please, Lord. Here in this case, my lord, petitioner is the in-charge Gabura, my lord, of the military village, my lord. My lord, accordingly, like the earlier case, my lord, he has also participated in the selection process of the regular Gabura, my lord, and he is also rejected.
No, but he says you don't have the age
My lord,
qualification.
my lord, in para 11, I have mentioned I came to learn from the
Yes,
sources, my lord,
Lordship,
it is not
yes.
specific.
Just
my
a
lord.
minute, just a minute. Let him finish, then you will argue. Yes.
My lord, in para 11, I have mentioned that I came to know from the sources, my lord. It's not, although I did not,
When was the advertisement published?
on 3/9/2022, my lord.
3/9/2020. What is
Page
the
20.
age requirement? Let us see. Page number?
Page number 20, my lord. Type copy, my lord.
What is the age requirement? Which
He
clause?
should be, my lord, 30 on 2/9/2022, and maximum age should be 65 years. my lord.
Which is the relevant clause?
Paragraph 2, my lord, at the last. Page 20, last paragraph, my lord. Minimum qualification is there, my lord. The first one, candidate should be citizen of India. Number 2, the minimum age of applicant should be 30 on 2/9/2022.
So what was the age of the petitioner on 2/9/2022?
Yes, Lordship,
My lord.
page 13. Page 13.
31/12/1993, my lord. 31/12/1993, my lord. Is date of birth, my lord. As per the HSLC admit card, my lord.
So he was not 30 years old as on 2/9/2022. That's correct.
Yes, my lord.
So what?
I'm, my lord, selling them, my lord, in my birth certificate, my lord, it is 9/6/1991, my lord. As per my birth certificate, is the admit card I have lost, my lord, it is wrongly recorded, my lord.
Then get it changed first, then come.
My lord.
All right, hard Mr. Hazarika, learned counsel for the petitioner.
My lord, instead of dismissing, my lord, kindly remand back the matter as appellate provision is
No,
there.
This writ petition is not maintainable. The applicant herein claims to be the in charge Gaubura of charge number 20 of village Medhirtari Kisamat under Jania Moja of Bagvar Revenue Circle. In response to the advertisement notice dated
3/9/2022, my lord.
what is the date?
My lord, 3/9/2022, my lord. 3rd September 2022.
3/9/2022 issued by the
My lord, Deputy Commissioner Borpeta.
Additional Deputy Commissioner, Borpeta District, inviting applications for appointment as Gaura of Bagbar Revenue Circle, inter alia for appointment of Gaura of Bagbar Revenue Circle. The petitioner had submitted his application. However, at the conclusion of the selection process, the petitioner was not selected. Hence this writ petition. Full stop. Resisting the prayer made in the writ petition, Mr. T.C. Chutia, learned additional government advocate Assam, and Mr. S. Datta, learned standing counsel, Revenue and Disaster Management Department, have both submitted that the petitioner did not meet the age qualification criteria as on the date of the application, and hence his case was rightly not considered. From a perusal of the materials available on record, it appears that as per clause 2 of the advertisement notice dated 3/9/2022, the minimum age of the applicant ought to be 30 years as on 2/9/2022, and the maximum age should be 65 years. According to the date of birth recorded, according to the age recorded in the petitioner's HSLC certificate. Where is the certificate?
My lord, certificate I have lost, my lord. There is a police report also, my lord, that I have, as page 35, my lord, I have filed a.
Page 13 here is stated.
Page?
Page 13, 1-3.
1/3 I have stated, my lord, I have lost, that is my.
Page 7 line.
Page 35, my lord, is the police report, my lord.
It is pertinent to mention here in there the date of part of the petition is wrongly mentioned the 31/12/1993, the HSLC admit card. We admitted.
The date of birth of the petitioner recorded in the HSLC certificate is 3/9/2002. Full stop. If that be so, the petitioner was evidently less than 30 years old on 2/9/2022 and therefore was not qualified to apply for the post of Gaubura in terms of the advertisement notice dated Date of birth is
My lord, 31/12.
1993.
Advertisement is 3/9/2023.
31/12/1993.
93, my lord.
28 years, 8 months, 1 day.
Full stop. The petitioner's counsel, however, submits that the HSLC certificate does not record the correct age of the petitioner. Full stop. However, this certificate is not, the HSLC admit card, certificate, no, admit card is not available on record from the amendments made in paragraph number 13.
Page number 13. 11.
In
Paragraph
paragraph
number
number 11
11, page 30. my lord.
of the writ petition, it appears that the HSLC admit card of the petitioner has been misplaced. Full stop. Be that as it may, by the own showing of the petitioner, his date of birth has been recorded in the HSLC admit card as 31/12/1993. If that be so, the age of the petitioner was below 29 years on 2/9/2022. Under the circumstances, I find sufficient force in the submission of Mr. Chutia that the petitioner was not qualified to apply for the post of Gavura on the date of Gavura as per advertisement notice dated 3/9/2022. Full stop. If that is so, the question of granting any relief to the petitioner in the context of the facts and circumstances of the case does not arise, this writ petition is accordingly closed.
Deeply obliged. my lord.
Yeah, please, Lord. So petitioner also is working as a Anganwadi helper also for the last 13 years and she is seeking promotion as Anganwadi worker also. There is a lots of advertisement lots in terms of the advertisement lots. She
Will
applied.
issue notice at this stage?
Lots I am challenging the annual report lots. There is no consideration. There are several complaints and representation. Lots may kindly see page 47.
In any case, whatever you say, we'll issue notice.
Lots.
What else can be done? You tell us what else can be done.
Only an interim order lots that the director will not act upon the inquiry report also.
That without the affidavit is not possible. Heard Mr. Eskedas, Landed Counsel for the petition. Being entirely aggrieved by non-consideration of our case for promotion from Anganwadi helper, from Anganwadi helper to Anganwadi worker. The petitioner has approached this court by filing the instant writ petition, contending that the inquiry report contains several untenable facts which cannot be acted upon at this stage. Full stop. Mr. Das has also prayed for an interim order restraining the authorities from acting on the inquiry report dated
13/1/2023.
13/1/2023 bracket annexure.
Annexure 18 lots. This is the forwarding and the lots report is at page 47.
Annexure 18. Mr. J.K. Parajuli, learned
1, 2, 3.
Government Advocate Assam appearing for respondent numbers 1, 2, and 3, prays for some time to obtain instruction in the matter. Why have you implemented them by name?
Because I have endless malafide against the selection committee. Binadabi and
They are allowed issue notice returnable in 4 weeks. Since Mr. Parajali has accepted notice on behalf of respondent numbers 1, 2, and 3, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition be furnished to the learned departmental counsel so as to enable him to obtain instruction and file affidavit. Considering the facts and circumstances of the of this case, this court is not inclined to issue notice to the respondent numbers 4 to 7 at this stage. The question of issuing notice to the said respondents will be considered at an appropriate stage.
Till then,
Therefore, interim order will be considered on the returnable. Till then, what?
Lordship, if the anchor report is acted, because in the anchor report, Lordship,
It will be acted.
the name
This
of-
kind of a relief cannot be granted.
name of the respondent number 7 has been recommended, but Lordship, she is only class 9 pass, Lordship.
We'll see that.
And other can,
You have made your submission, we have considered. Let's put it at that.
all right.
Time being matter, I don't know.
Yes, what is the matter?
Well, petitioner seeks compassion appointment. Consideration of his application. Well, I have instructions, my lord, it has been considered. And financial vitals have been also, my lord, measured, my lord, which led to his rejection, my lord. So, my lord, I'll bring that on record.
Where is the order of rejection?
My lord, that is not with me, I'll bring on record, my lord. I'll file an affidavit. my lord.
No, no need to file affidavit. You just give a copy to him.
I'll
My
pass
lord,
it.
I have seen, my lord, make close it, my lord, and liberty
When?
may be granted, my lord, for challenging the
Rejected when? By order dated?
That is.
Mr. Hazarika, counsel for the petitioner. Peruse the order dated 2012-2022 passed by this court. First up, the grievance of the petitioner is that his prayer for appointment on compassionate ground has not been considered by the authorities. First up, Mr. D. Gogoi, Learned SC, APDCL, appears and submits that the prayer of the petitioner has been considered and rejected by issuing a separate order. At this stage, Mr. Hazarika seeks leave of this court to assail the order of rejection of the prayer of the petitioner by filing appropriate petition. Prayer allowed, this writ petition stands disposed of on withdrawal with liberty as grateful.
All deeply obliged.
Supplementaries list, orders made in item 60.
Well, this application has been preferred by Union of India, my lord, for stating, my lord, interim order dated 28/12/2022, my lord. He is an employee, my lord, grade A officer of Indian Postal Service. Presently,
Where is the order? Where is the order you want?
Page number 17
page
of
number
the I.
7 of the I, my lord.
The operative part is the page.
No, you have to go one by one, or
Yeah.
else you do it outside.
Oh, Lord.
Inside the court, both of you cannot argue. Two options. Which do you want to take? You can argue outside the court, or if inside the court, it has to go in
Lordship,
orderly. manner.
Lordship under your person.
Under the court. Okay.
My lord,
That's a
operative
good
part is
choice.
page 18, my lord.
Yes.
Well, my lord, he was transferred, my lord, by the order dated 23rd. My lord, may come to page number 20, my lord, first paragraph, my lord. Then 23rd, 11/22 is the, my lord, order first, my lord, transfer. And they challenge the order is before the Learned Care. And Learned said, my lord,
First of all, what is the operative part of the
my lord,
order dated 23/11/22 and 12/12/22?
page 21, last paragraph. In view of the other till reasonable date, it is due to the direct page 21, last paragraph, my lord. Stay the orders dated 23rd 11/22 and 12/12/22. 23rd 11/22 is the transfer order, and subsequent order is the 12/12 is the representation rejected. That is the order, speaking order 12/12. My lord, fact is that, my lord, that 12/12/22, whereby his representation was rejected, that order was challenged before the CAT, my lord, again by a second, my lord, way, that is 276 of 22. On 22nd of December, my lord, only stay not given, only, my lord, admitted and stay not given, if notice was issued. Thereafter, immediately they have filed the writ petition on 26th of December, my lord, annexing a petition where they we want to withdraw the petition. They have annexed one petition, but this matter came before the vacation bench on 28th of December, my lord. On that day, that OA was still pending. They have only filed a petition, my lord. Subsequently, we have come to know that on only 3rd of January, that OA has been, my lord, closed and withdrawal, my lord. Till at the time of passing the stay order, my lord, because we are also not, my lord, any instruction because it was come before the vacation bench, my lord. And on 28/12/22, that way before the CAT was still pending. And during pendency of the case, we have only because of my lord that stay order not granted on 22nd of December, the stay order not granted because of that. And regarding my lord stay order, they have to come before the division bench of this court, my lord. Regarding stay order, they have to, if they file any appeal, they have to come to the division bench of this court, my lord. Only annexing that document, and during the course of hearing, they have not disclosed, that was not argued, that way was pending.
My lord, we have already.
He has not yet
Oh,
finished.
my lord.
And he is a grade A officer. He is posted in Tezpur since 4/9/15 to 1/3/17. Subsequently, for a term of 2.5 years, he was posted to Guwahati. Again, from September, July 2019, 15/7/2019, he is in Dorong. And on completion of the term of 3 years, he was transferred to Kasar. That order dated interim order of transfer 23rd of 11. Already in July 22, 3 years completed. They have stated in the petition one way regarding transfer policy 4 years is the term that is not applicable to the petitioner because he is a grade A officer. So as because the line at CAT didn't stay, they have though they have annexed the application in the last page of the requisition, page number 76. But on the day of the interim order, that way was still pending. And by representing the facts, they have obtained the stay order.
It is not. I know.
Where are these orders 2311 and 1212?
2311, the order in the requisition.
28 space to 30.
Page
28 to 30 in the main writ petition.
Requisition.
Page number 29.
Page 29, serial number 1, top, Opposite partner, as a senior superintendent post office, Dorong division, Tezpur, to Kasa division. And second order is representation, page 31, Annexure B, whereby his representation was rejected in terms of the CAT order.
So he is in Tezpur since when?
2015.
Since
He joined in 2015. He was there for 2.5 years. Then he was again posted to Guwahati for 2.5 years. In 2019, he was again transferred back to Tezpur. So their admission in their IA stating that they have followed the guidelines of the government of India, where they have stated that without completion of 3 years, they have not transferred this petitioner. But within the stipulated period of time, he has been transferred 4 times.
So is it mandatory that if there is a tenure given? See, both of are in a hurry, but the moment I start asking questions, you will ask time to take up. So don't be in a hurry. Have patience. Have patience. You cannot answer questions that I'll ask. So have patience. Where is the judgment of this court which says transfer orders can be issued even in 1 day? Where is the judgment? Give me the judgment. Done? Take your seat. I can ask you more questions, you cannot ask. So don't be in a hurry. The court is trying to understand the case. Where is the judgment?
My lord.
Where is that judgment?
My lord will produce it before.
Next round, you do it in the next round.
my-
This round, I'm not adjourning it
My-
because you are showing a lot of
My lord,
urgency. Yes, what do you have to say?
my lord, in my case, since I have been transferred
Hmm,
like 4 times in 7 years,
hmm.
there in their IA they have stated that it is within the Assam circle, so it is permissible
Hmm.
that within 3 years I can be transferred.
Hmm.
But as per the government guidelines, out of station, that means if I'm in Despur, and if I'm transferred to Guwahati, it is out of station. Though it is within the Assam circle, but I'm not carrying that post, my lord.
31st March, if both of you are agreeable, we can pass an order. Otherwise, I'll pass the order inside the court. Transfer matters, the courts will not sit in
31st
it.
March is too long, my lord.
Then we can't help it.
My lord, kindly, my lord.
My lord,
Because he has an academic
My-
session.
My lord, he is a my lord, sensitive post, my lord, and some inquiry also going on, my lord, that is, I have.
That's correct,
Yeah.
but
And
31st
my lord-
March, the academic session will come to an end.
yes,
All he is asking is accommodation for 2 weeks,
Mine.
or let us assume that he is not asking for it.
my lord.
Since already there is a stay order, you give effect to the order after 31/3/2023. He has to join. He has to give an undertaking. That
Yes,
he join.
yes.
But,
Give me,
in that case, my lord, instruction also, my lord, without instruction, my lord, I'll file a affidavit also, my lord, because I stay vacating, I have filed, my lord, in the repetition, my lord, if my lord going to dispose of, my lord, I have not filed affidavit also, my lord, don't get time, my lord. Will, by getting that answer, my lord, by that point, my lord, I will file an affidavit also.
Yes, that's all. Whatever has happened has happened. There is already a stay order.
Right.
Technically, it is not there.
But technically, my lord, during the pendency of the CAT, my lord, they have actually not disclosed, my lord. Subsequently, only that was rejected, my lord.
It's all right.
my
We'll
lord, we
close.
have already presented in the petition.
Why are you disturbing the court?
Oh, my.
Hmm.
On 28/12, Malat, the stay in the Malat vacation court, it was Malat presented.
See, Mr. Parasar, the point is 31st of March is barely
Yes,
2
Malat,
months
that
away.
that is.
You may not be able to get him anywhere in next 2 years also if the litigation continues. We are trying to provide a way out. Try to apply your mind.
Malat, yes, Malat.
You
That's
can
why
write a big judgment and we can deliver the judgment after 31st March also. Can you do anything about it? When the court is asking you
that is
that
why I'm pointing out, Malat.
other things left aside, he is living with his family. He is a
Yes.
9-year-old child
That,
who's in the mid-academic session. So why don't you allow him to continue for 2 months?
Malat,
If he gives an assurance that he would comply with the order after 2 months, we'll make the way. And of course, law is settled. Legal matters we can deal with legally. There's no difficulty. But this is a writ court.
Malat.
We're not it's not a civil court where a munsif is dealing with a civil matter. We'll apply our discretion.
My lord.
Heavens will not fall if you can defer it by 2 months. You obtain instruction, we'll close it.
Malat.
Huh? But that is provided he gives an undertaking. Otherwise, we'll pass an order on merit.
Malat may reflect that, Malat, I will bring an instruction also, Malat. Malat may reflected that in the order, Malat.
Heard Mr. K.K. Parasar, learned counsel for the applicant. Also heard Mr.
W.R. Medi.
W.R. Medi, learned counsel appearing for the OP stroke read petitioner. Full stop. This IA has been filed with a prayer to vacate the order dated
28/12.
28/12/2022, passed by the learned single judge in WPC number 8455/2022. Mr. Parasar has asked several grounds seeking vacation of the order, including the ground of suppression of material facts by the petitioner. First of all, the case of the writ petitioner, on the other hand, is that entirely is that his child is in mid-academic session, and therefore, and considering the fact that the transfer order has been issued in violation of the standing guidelines, there is no scope for vacating the interim order. First of all, after hearing submissions of learned counsel for both sides, while this court is of the opinion that there is very limited scope of interference by the writ court in an order of transfer, and that law is firmly settled that violation of standing orders by itself cannot be a ground to stay an order of transfer if the same has been issued bona fide and in exigencies of service, yet being the root court, this court cannot also be oblivious of the fact that the child of the petitioner is in mid-academic session, which should come to an end on 31/3/2023. And therefore, if he seeks little accommodation on that behalf, there is no valid reason for this court not to consider the same. Responding to the above, learned counsel for both the sides have prayed for 3 days' time to seek instruction and respond to the above. Depending on the response obtained by the parties, learned counsel for the parties, an attempt can be made to dispose of the writ petition itself. Office to therefore list the writ petition along with the IE for admission on 1/2/2022 as a fixed, 2023 as a fixed item. Interim order passed earlier to continue till then. You come up with instructions and we'll see what can be done. You see, these transfers are creating problem nowadays. First of all, people have their domestic reasons why they are resisting. Technical law is something, so you have to strike a balance.
Yes.
31st of March is the maximum we can consider for him. Nothing beyond that. And that too, he has to give an undertaking. Within 3 days of the order, he has to give an undertaking before the authority that he will join in the new place of posting on or before 1st of April. Subject to that, we can consider his prayer, nothing more. And he will not challenge any order. Challenge this order. These two undertakings given, we may consider it. Otherwise, we'll go by, we'll pass orders as per. All right? Yes. And if both of you want to argue the next day, do it outside. Not inside, okay?
May I please, your lordship? My lord, on last occasion, respondent number 4 to 6 prayed for time to file affidavit.
May I please, your lordship? I'm for respondent 1, 2, 3. Lordship is an all matter and the brief has not been handed to us by the earlier standing council. So lordship may grant us one.
Who is the earliest standing council?
Lordship, I'm not aware. It's a corporation department.
Then we'll allow with the petition. What is the relief?
My lord, we are praying for setting aside the appointment of respondent 4, 5, and 6, my lord.
As
My lord, actually, in terms of an advertisement, my lord, petitioner applied for the post of peon in the corporation department, my lord. The corporation, the respondent number 4, though shown to have been cleared the written status as a general category candidate, but he was appointed in a reserve post. And the respondent number 5 and 6, their name do not appear in the select list published where the candidates have cleared the written test, but they are appointed.
So who is the petitioner? What is his locus here?
He's one of the candidates, my lord. He also applied. He is the OBC candidate.
His appointment is in which organization?
Corporation department, my lord.
Huh? Corporation?
Yes, my lord. Actually,
Is there, what is the corporation department?
Cooperation department.
Cooperation. You are appearing for whom?
I'm appearing for the department, your lordship, respondent 1, 2, and 3.
These appointments are in the department or in the cooperative society?
Actually, your lordship, I don't have the brief of the case, your lordship. Actually, it has not been handed over by the earlier standing council. So I have requested my friend to serve me a copy of the writ petition.
Yes. What do you have to say?
They have not provided me, please not open by that.
Who has not provided it?
Petitioner.
My lord, on last occasion, they prayed for time. I have taken steps, my lord. Earlier, they were not parties in terms of the direction issued to the corporation department, my lord. They were implicated as parties.
Subsequently, have been implemented, my lord.
On last occasion, they prayed for time. My lord, kindly say last order 25/2022.
So what is to be done today?
If they don't have copy, I will serve. I have
Right.
taken steps, man.
All right, heard Mr. S. Chakravarti, learned counsel appearing for the rate petitioner. Also heard Mr. G. Bordoloi, learned standing counsel corporation department as well, who submit that the papers are missing in his office, as a result of which he is not in a position to take a stand in this rate petition. Similarly, the submission of Mr. A.K. Azad, learned counsel for the respondent number 4,
4, 5,
none, 4, 5, and 6, situated thus, and in view of the nature of controversy involved in this proceeding, the petitioner's counsel is directed to furnish copies of the writ petition to the counsel for the respondents within a week from today. At least this case, this being a very old matter, calls for expeditious disposal. Therefore, let this writ petition be listed again on 28 February 2023 as a fixed item. The respondents counsel to positively obtain instruction and file affidavit in the meantime, if so advised.
All right.
Item 12. Item 12.
None appears for the petition. What is this?
Lordship, the petitioner wants promotion, Lordship. He is a physically handicapped person and he wants reservation in promotion. The notification very fast clear, Lordship. In grade 1, it is limited to grade 3 and grade 4 only, Lordship. Not.
He is in which grade?
He is the assistant junior engineer, Lordship.
Mr. N. Upadhyay, learned standing counsel, water resources,
Irrigation,
department
Lordship.
is present. Since the petitioner's counsel is absent today, this matter stands adjourned for.
Lordship, last occasion also he was not present. No.
It is made clear that if the, no, full stop. It appears that the petitioner's counsel was absent even on the previous occasion. Therefore, it is made clear that if the petitioner remains absent even on the next day, consequential orders will follow.
All right.
Item 13.
Lordship, the petitioner is seeking promotion to the post of senior assistant in the office of the Assistant Director of Employment District.
Court can't grant promotion.
Lordship,
Courts cannot grant promotion.
yes, Lordship, but they have.
What is the law? What is the law?
Lordship,
What is the law?
he can be considered for promotion, Lordship. That is what he is seeking, Lordship, but he is seeking it as a PWD candidate, Lordship. There are vacancies available, Lordship, but the department is not.
He is in
considering
which thing?
He is presently serving. Yes, Lordship, as junior assistant in the District Employment Exchange, Lordship, Barpeta, Office of the Assistant Director of Employment, Lordship.
Physically handicapped.
Yes, Lordship.
What is his physical deformity?
Lordship, he is hearing impaired, Lordship. And paragraph 11, Lordship.
In promotion, PWD is
Applicable, my lord.
applicable.
Yes, my lord.
And he is entitled to be considered for which post?
My, from junior assistant to senior assistant, my lord.
This is a grade 3.
My, grade 4 to grade 3, my lord.
Now he is in grade 4.
He has been promoted.
He has been promoted.
No, not effect from the date that he was eligible, Lordship.
That is another matter. That for that you have to file another writ petition. Mr.
But
MP.
herein now we have prayed for that, Lordship.
Hmm?
From the date he was eligible, Lordship, we have prayed for that, Lordship.
You have to challenge the order of promotion. You can't get it here.
Lordship.
Because you don't have the pleadings. You don't even know what the order is
Yes, Lordship.
when you filed it. Where is the order? Let's see. Heard Mr. Mr. A. Chatri, is it? No.
I am
MP Sharma. There are counsel appearing for the writ petitioner. The petitioner is aggrieved by non-considerable petitioner who is serving as junior assistant in the employment exchange at Borpeta is aggrieved by non-consideration of his case for promotion to a grade 3 post. against a PWD category as a candidate belonging to the PWD category. Full stop. When was he promoted? 2019. Today, when the matter is called up, Mr. SP Das, Learned Counsel, appearing for the respond numbers
3 and 4, madam.
3 and 4, has produced a copy of the office order dated 15/7/2019, which goes to show that serial number
54, I think, madam. Mentioned in the first statement of the instruction.
has already been promoted to the post of senior assistant. If that be so, the basic grievance of the petitioner in this writ petition appears to be redressed. At this stage, Mr. Sharma submits that the petitioner has not, the promotion of the petitioner has not been given effect to from the date on which he was eligible. Full stop. That, in the opinion of this court, would be the subject matter of a fresh petition. And the aforesaid aspect of the matter cannot be adjudicated in this writ petition. Full stop. Therefore, by granting liberty to the petitioner to file appropriate petition, ventilating the above grievance, if so advised, this writ petition stands closed.
You may give me a
Ms. S. Burwal and Government Advocate Assam is present on behalf of the state.
You may give me a copy of that order, Lordship.
Your client will give you. He is serving since 2019. He has not met you with a packet of sweets or something like
No,
that.
no, Lordship, we have lost our contact.
You must first sue your client and then. He doesn't want to come. You see, if he comes, then
Lordship.
he has some other obligations also. No?
Maybe, Lordship.
Corona time, very difficult. You give him a call, then he'll.
Item 14.
Maybe the Lordship. Lordship, the matter pertains to Lordship grant of SCPS scheme, Lordship. Lordship, the petitioner had joined in service in 1984 under SC Assam Civil Service grade 2. Lordship, subsequently those were merged in 1989 as Assam Civil Service. Lordship, in 2005 he was granted promotion to Lordship senior grade 2, Lordship, SCS senior grade 2. Lordship, in the meantime, Lordship, in 2011 the SCPS scheme came into effect. Lordship. So Lordship kindly comes to page 14.
SCP's career progression, what is it?
Lordship, assured career progression.
Assured career progression.
scheme, Lordship.
Those people who don't get promoted
Lordship.
after on hitting the eligibility note,
Lordship.
they are entitled to
Lordship.
enhanced pay.
Lordship.
So according to you, petitioner was entitled for that. When was he entitled for that?
During his entire service career, he was granted one promotion, Lordship, in the year 2005.
Hmm.
Lordship, and under the scheme, Lordship, upon
He is retired from service.
Lordship, he has retired from service.
When did he retire?
Lordship, he retired on 31st of January 2014, Lordship.
31st of January 2000.
14, Lordship.
And 3 years after retirement, he has come to the school.
Lordship, he had referred a writ petition in WBC 4603 of 2015, Lordship.
Hmm.
As he was not granted the benefit, Lordship, this honorable court directed the respondent authorities to consider his case and pass a recent order, Lordship. That order is at page 36, Lordship. Annexure 8, Lordship.
Page 36. Hmm.
Lordship. May I read it, Lordship? Lordship, whereas Mr. Uday Kumar Bora submitted a petition dated so and so for allowing him the benefits of assured career provision scheme. Whereas the screening committee for assured career provision scheme in its meeting held on 17/9/2014 recommended that the benefits of financial upgradation to SCS senior grade 2 time scale with grade pay of 7,200 under assured career provision scheme for the eligible officers may be given effect with effect from 1/9/2014. That is the month in which the meeting was held. And whereas the petitioner had retired on 31/1/2014, that is prior to the meeting was held. Whereas the cases of the petitioner along with few others similarly placed who retired earlier were not placed before the screening committee election. Finally, Lordship,
At the bottom, Lordship, it concluded whereas the representation was considered and after careful examination, the personnel aid department has decided not to allow the petitioner the benefits under assured career progression scheme. As the screening committee has decided to allow the eligible officers the benefits under the assured career progression scheme with effect from 1/9/2014 and not with effect from 1/1/2014, and the officer so and so has already retired by then.
So SCP has been given, but with effect from 1st September.
1st September.
You want it from 1st January.
Lordship, since he had already retired, Lordship, his case was not considered.
Second.
Lordship, he had retired on 31st of January 2014, Lordship. SCPS was given effect from 1/9/2014. May I read the last paragraph, Lordship?
That's all right, but what is the wrong if it is given from 1/9?
Lordship, if your Lordship kindly comes to page 14, Lordship, the SCPS scheme, Lordship.
Hmm.
Page 15 would be relevant. Page 14, Lordship, paragraph 2.
Page 1/4.
Lordship.
Hmm.
Lordship, paragraph 2(6), Lordship. Down below, Lordship.
Hmm.
May I read it? Lordship, to make the SCP scheme operational, the cadre controlling authority shall constitute the first screening committee within a month from the date of issue of this notification to consider the cases maturing up to 30th of June 2011 for grant of benefits under the SCP scheme, Lordship. Lordship. So the respondent authorities were to
So
consider.
where is the guideline for considering in SCP?
Lordship, the SCP, Lordship, page 15, the date of effect, Lordship.
Hmm.
Lordship, the scheme would be operational with effect from 1/1/2011. In other words, financial updations as per the SCP scheme would be granted with effect from 1/1/2011. Now, the
Yes.
selection committee, Lordship, modified it on their own, as per their own wishes, Lordship, to 1/9/2014, Lordship.
That is what I am asking. Since the petitioner retired on the fact that he is entitled to SCP, that is not in dispute.
Right.
Because they have themselves given it.
Lordship, we have not been given. Lordship.
Why?
Since
From
I had retired prior to the setting of this screening committee. May I read?
others similarly can
Lordship.
situated. So according to you,
Lordship.
you were entitled to receive it from which date and on what ground?
Lordship, I had completed 24 years of service on 2008, Lordship. I had joined in 1994. Lordship,
You retired as what?
Lordship, I retired as Lordship.
January 14.
SES senior grade 2, Lordship.
What was the post you were holding?
Post, Lordship. Post, Lordship,
So you come prepared because these matters will require us to go into every minute details.
Lordship.
You come, what is your stand, Mr. Chitia?
My lord, we have filed an affidavit, my lord.
Hmm.
We have stated in our paragraph 3, my lord. Affidavit filed by record number 1 and 4. The financial department had issued a notification for employees of government employee by notification that it is mentioned in the notification that scheme would be operational 1/1/2011. It is also mentioned in the notification that each department shall constitute a screening committee to consider the cases of the grant of financial upgradation under the SCP scheme. Accordingly, a committee was constituted in personnel aid department by notification dated 8/8/2014. That was only constituted 8/8/2014. The screening committee in its meeting held on 17/9/2014 recommended the names of the officers found eligible for financial upgradation as reflected in the notification dated 10/18/2014. The committee decided to recommend financial upgradation with effect from 1/9.
No, Mr. Chutia, these things are not relevant. We want to know what was the criteria.
Okay, that is
Your committee sits after 8 months. People will retire. That doesn't mean that they will be denied. How can that be? Then in that case, so many things will go haywire.
There must be criteria.
Government may take time to do a few things, but the issue is whether he was entitled to receive it on a particular day. Neither he is being able to answer it, nor you are giving an. What is the criteria?
That is not mentioned here.
That criteria cannot be subsequently designed. It has to be the criteria settled in the year 2011. What is the criteria?
That is not mentioned. In this regard, I will have to obtain instruction. What is the
That is the only thing that is required to be gone into. No other instruction is relevant here.
That's why, my lord, our this imputed order says like that, my lord. Imputed order also, my
Imperial
lord.
order I've read. I've read.
Lordship, page 17, if your lordship produces lordship.
Hmm.
Lordship, it states only 2 financial obligations will be admissible if
Hmm.
no regular promotion is given to the employee during the prescribed period of 24 years.
Hmm.
And if an employee has got 1 regular promotion, he shall be qualified for the second financial.
So
obligation.
where is the pleading saying when was he first entitled to promotion? Where is the pleading? How many applications were entertained on that year? Whether the petitioner's application was one of them, where are the pleadings? Show us. Then we cannot do anything. It will be deferred. You are Mr.
Yes, Chakraborty.
Learned counsel for the petitioner. Also heard Mr. Chutia Learned Additional Senior Government Advocate Assam appearing for the state, and Mr. P. Nayak, Learned Standing Counsel, Finance Department. First of Mr. R. Dhar, Learned Counsel is present on behalf of. Who is respondent number 3? Respondent number 3. First of, the petitioner is aggrieved by non-consideration of his case for grant of assured career progression, ACP benefits. Full stop. The petitioner had retired from service as a senior grade SES officer with effect from 31/01/2014 upon attaining the age of superannuation. Full stop. It appears that the screening committee had decided to grant ACP scheme to the beneficiaries with effect from 1/9/2014 and not from 1/1/2014. That appears to be the only reason why the petitioner was not granted the benefit of ACP. However, neither side has been able to bring on record material facts and particulars indicating as to what criteria was laid down for consideration of such claims, on which date was the petitioner entitled to receive benefits of SCP, and in what manner, and how the rejection of his claim was discriminatory and violative of the laid down government guidelines and notifications. Unless those aspects of the matters are brought on record, it will not be possible for this court to adjudicate on the claim of the petitioner and issue a writ of mandamus. Be that as it may, on the request of learned counsel for both the sides, this matter stands adjourned for 4 weeks so as to enable them to do the needful. We have to come up with a complete clear case. These are financial matters. It will take him another life to get a benefit out of it if the order is not correct. You only want some order directed to consider these, that. These orders are not yielding any result. Only thing that is doing is multiplying the cases coming to the court. We will not pass this kind of orders. If you want order, you have to come crystal clear, showing what is your claim. Then
Petitioner herein has been working as a sweeper at the branch of the SBI Lordship since 1998. That Lordship will find for page 13.
yes.
Now, from page 14, Lordship will find that the post is a permanent post lying vacant, and he was allowed to temporarily work, Lordship. The branch manager has written to the head office, Lordship, for his absorption. Now, Lordship, there is a policy under the bank. Lordship will find page 26, Lordship. Page 26. It's read as Lordship, monitoring of implementation of rule of reservation in SBI. So anybody is working on a temporary basis as sweeper or general attendant, names are short for, Lordship. And on the next page, Lordship will find my name was sent, page 27. According to the format short for, Lordship. It was sent in 2009. Since then, nothing was happened, Lordship. So I approached this court, and after I have approached this court, Lordship, they have discontinued and engaged another one person, Lordship, that they have stated in their affidavit, Lordship. So whether they could have replaced one ad hoc by another ad hoc, Lordship.
State of Pyara Singh already.
Lordship.
Where is the judgment?
1992, Lordship.
Have you bought the decision?
No, Lordship, I have not.
That order has not been stayed.
Order is not. It was after I had filed the writ petition, notice was issued.
First, I'm for the bench here. First thing is that the petitioner is here before this court
on 3 grounds, Your Lordship. First is for that his length of service is for from since 1998. And second is for regularization, Your Lordship. And third is that there is an suggestion from the branch manager to the head office regarding his regularization, Your Lordship. First thing, the petitioner herein, he is not engaged directly by the bank. He is engaged through an outsourcing agency as a sweeper of the bank. And to that extent, Your Lordship, we have annexed the bill which we used to give to the outsourcing agency for availing the service of the petitioner. It is not a fact that the petitioner is directly engaged by the bank for as a sweeper in the bank, Your Lordship. Yes, as page 14 of the affidavit in opposition, we have annexed it, Your Lordship.
In my affidavit, nothing has been annexed, Lordship.
Oh,
Annexation.
without this document, then how will you,
Annexation
you can't proceed further?
Annex will be what this is illegal. Like annex to page 4, to para refer position.
Page 4.
Page 4.
Achha.
Behind the into.
Mr. Chakravarti, we have to deal with this issue.
Lordship, let it come after a week, let me go through that.
I'll
Annexure,
provide the
Lordship.
annex.
And let me take instruction to that.
Mr. B. Chakravarti, learned counsel for the petitioner submits that the affidavit in opposition filed by the respondent bank is not complete with the annexures, and therefore he is not in a position to.
Lordship, this bill is in respect of the newly engaged man, pro their contractor Amrish Kumar.
So that is why you need to respond
Not
to
in my,
it.
not in my name, Lordship. Not in my name.
So you respond to it then, because ordinarily we wouldn't like these matters to be delayed further, but then what to do?
In any case, it is not.
And therefore he is
affecting-
not in a position to respond to the allegations, respond to the submissions made by the learned counsel for the respondents. Full stop. Mr. H. Buragwai, learned counsel for the bank, has assured this that during the course of the, he will furnish copy of the counter affidavit filed by the bank, complete along with the annexures. In view of the above and on the request of Mr. Chakravarti, this matter we listed again after 10 days so as to enable him to obtain necessary instruction. We'll close it. You see, come up with that Pyara Singh versus State of Haryana. These are all, thereafter also number of decisions are there. You cannot replace one temporary ad hoc with another ad hoc. You can't do that.
Obliged.
Item 16.
This was an ACS officer. He required for her next promotion. So approach for the unable to. Those he was SC community was it. There he was in the strength of
What is the post petitioner is holding now?
Lordship, he already retired.
He is already retired. So then what promotions he can get?
Our another person for that is pension and benefit. Also one of the parents. What happens in
And here it in due course then. There is no.
Very nice. We have had at the time of the motion, there is the order of the honorable court, then any promotion subject to outcome the leaves, but they already promoted one person.
No, you can't get promotion.
That's it.
All you see, the only relief you can get is whether you are entitled to consideration.
That's it.
But then how that order can be now, what will it give you? Promotion is always a matter of DPC. So even if the court holds that you are entitled to be considered,
Then
you don't get anything. So you don't get anything today or you don't get anything after 6 months. You can choose which you want. How can you get? Huh?
My lord, I'll be appearing for respondent number 4, WPTDC, my lord. I was not served the copy since marriage. My name is not there.
Will issue rule in this case. Heard Mr. N. Govind and counsel for the petitioner. The read petitioner is aggrieved by non-consideration of her case for promotion to the next higher grade It appears that the petitioner is already retired from service. Mr. Gogoi submits that his client is seeking pensionary benefit if she succeeds in establishing her claim. Mr. T.C. Chutia Leonard, Additional Senior Government Advocate Assam, is present on behalf of respondent numbers
1, 2, and 3, my lord.
1, 2, and 3.
No, 2, 4.
Mr.
You are 4.
Mr.
Dhar
R.
is
Dhar
four.
for respondent number 4 and Mr. P. Nayak for respondent number 5. Mr. Dhar submits that he has not been furnished with a copy of the affidavit. Mr.
Copy 4.
In view of the above, the petitioner's counsel to furnish copy of the affidavit to the learned counsel for the respondent number 4. This matter will be posted again after 4 weeks.
My name is in the corporate now.
By showing the name of learned counsel. to the
SAW.
respondent is established.
Highly obliged.
Item 17.
My lord, this petitioner seeks, my lord, appointment, my lord, what had happened? Another set of petitioners, my lord, in another case, they had also sought same relief, my lord. It was allowed the single judge. Then state went to appeal was dismissed, and my lord, now we have approached Supreme Court and Supreme Court stayed, my lord. So this goes
Then
on.
appears for the petitioner on call. It appears that the petitioner's counsel was absent even on the previous occasion. Mr. D. Gogoi, learned standing counsel, Forest Department, Assam, submits that the order passed by the learned single judge as affirmed by the division bench of this court in another similar writ petition allowing the prayer has been taken in an appeal before the Supreme Court, wherein a stay order is operated, and therefore this matter be adjourned for 8 weeks, awaiting the outcome of the SLP pending before the Supreme Court. Prayer allowed, let the matter be listed accordingly.
Item 18.
My lord, is a contractual employee, my lord. She has not been extended the benefit of, my lord, this child care, my lord, under SR 121. Contractual, she's still serving, my lord, and it's a covered case, my lord, of a judgment of this honorable court, my lord, where it has been held, my lord, contractual employees are also entitled, my lord. If I may pass on, my lord.
He is the contractual employee
Of
under
NHM, my lord, NHM. My lord, go to para 14, my lord.
Para 14.
Para 14. Having held as above, it must be also noted that petitioner in this case is not a regular government employee. She is a contractual employee in the role of the government. With respect to the learned judge of the High Court of Uttarakhand, a somewhat pragmatic approach may have to be taken in this regard. In this case, the initial contractual matter, in this case, there is a time limit, but in this case, we are still serving, my lord. So it can be adjusted by the authorities on a pro rata basis, my lord.
How long she has been in employment?
She is employed, my lord, from 2012, my lord. She is still serving. Since the inception of NHM, my lord. You, madam? Oh, 220 of 17.
What do you have to say?
Otherwise, she is entitled, my lord, but she has taken leave, my lord, unauthorized leave before maternity leave also. Therefore, a so-called notice was issued for termination, my lord. Against that, this petition was filed, my lord. That is in 52 page numbers.
This has been stayed.
Yes, it's a statement.
How can you terminate someone for seeking maternity leave?
No, my lord.
This is
She
the
was
most cruel
un-
form of.
Not for maternity leave. She was unauthorized. She was on leave.
All right, you
unauthorized
don't
leave
grant her
before-
leave. What is
before
she supposed to
maternity
do?
leave.
A person who is in a maternity situation,
Yes.
you expect that person to attend office.
Oh, my lord. Before taking leave,
What
she
is
was.
this? What are this kind of
Now
approach?
she is working in her, as per her request in Kamrup Metro, my lord, as she was requested in her representation, my lord. But regarding approval, as per my affidavit, my lord, approval of maternity leave, that is under process, that is filed on 2019, my lord. So for recent development, I have to take instruction. my lord.
I have annexed all time, my lord. It is started from the initiation, so from his, from
So,
her, my lord.
Mr. Gogoi, only the termination is under challenge.
Yes, my lord, yes.
Why are you going to the childcare leave issue? That's not the prayer.
No, my lord, the whole issue arises, my lord, she conceived, my lord, and some other gynecological issue arise, my lord. So she was taking leave on that account only, my lord, and invoking this provision, they say childbirth is okay, but other issues which raised out of the gynecological issue, but they have not taken into account, my lord. My lord, she is my annexures, my lord.
All right. Why didn't you come straight to the point? You are challenging the order of proposed termination.
Yes, my lord.
Which is under stay. She wants more time. Interim
My-
order will be extended. That's all how Mr. D. Gogoi learning come to appearing to the petitioner. The order dated 16/5/2019 issued by the mission director NHM. Issuing a show cause upon the petitioner as to why she should not be, her services should not be, her contractual services should not be terminated is under challenge in this proceeding system. It appears that by virtue of an interim order passed by this court, the petitioner is still continuing in service and she has been posted
In Kamrup Metro, rural.
in the Kamrup Rural Office, posted in an office in the Kamrup Rural District.
DME.
Full stop. It further appears that the action against the petitioner was initiated on account of the fact that she had remained absent during the period of her service on account of, no, she had remained absent from duty between 29/5/2018 to 1/10/2018, treating the same as maternity leave, which had invited the ire of the, although she was not apparently entitled to any such leave, and hence the same has invited the ire of the authorities. Full stop. If the department is not questioning the fact that she was in fact on a maternity call during the relevant period, then in that event, it is not understood as to how penal action can be initiated against a lady on such ground. Full stop. Be that as it may, Ms. A. Bora Lanet, Standing Counsel NHM, submits that the petitioner is continuing in service as of now, and therefore she be granted some more time to obtain updated instruction. Full stop. The question as to whether the respondents can deny CCL and or maternity leave has come up for consideration before the court on many occasions, wherein it has been categorically held that such leave cannot be denied to a deserving person. Therefore, in my opinion, the issue involved in the present proceeding would call for deeper examination. Issue rule returnable in 6 weeks, since the respondents are already represented. No formal notice is required to be sent in this case. You have filed affidavit?
Yes.
Let this writ petition be listed for hearing in usual course. Interim order passed earlier to continue.
All right.
Please tell your authorities that this is not how we treat. If it is disputed that she was making a false statement, that's another. How do you expect a woman to handle this situation?
My lord, that is, she She has taken leave from January, my lord. January 2018 as.
Madam, you know,
Yes,
there are many countries
yes, ma'am.
who take action against the parents if they don't go on leave for 2 years after a child is brought.
Yes, ma'am.
These are all necessary for the future of the country.
Yes.
Okay, if a child is not taken care of, then it will have a repercussion on the future of the country. That is why CCL leave. These things the officers must understand. It is not about any other person availing a casual leave and an earned leave to go on a holiday. That's not the case. These are compulsions which the authorities must understand, cannot be denied. We can't do it. This is a welfare state. The rights of a woman has to be respected. You must advise them to have that mindset. Of course, they are entitled to take their decision and we are entitled to look at it. We will do it. But this approach should be, proper approach should be adopted. Of course, if somebody is misusing it, somebody is coming up with a false plea, then the matter is different. Yes.
Item 19.
May please, Lord. My lord, regarding promotion, my lord, from 4th grade to 3rd grade, my lord.
4th grade to 3rd grade.
3rd grade, my lord. And initially petitioner filed a writ petition, my lord, which was disposed of, that is, my lord, order page 32 and except 12, my lord. Whereby it was directed, relevant portion, my lord, page 33, my lord. Bottom, my lord. The learned counsel for the state, however, submits based on the affidavit filed by the respondent number 2 on such and such that a vacancy was not available for promotion to the post of lower division assistant till 2015. The said assertion of the state, however, has been controverted by the petitioner, contending that there were as many as 4 vacancies available at the relevant point of time. In view of the above, the respondent authorities are directed to examine the existence of vacancies prior to the said notification dated such and such. And in the event vacancies are available, the case of the petitioner be considered for promoting him to the next higher post. Lower division assistant, as per the rule existing prior to the said notification, my lord. And thereafter, my lord.
Where are the statements showing how the petitioner comes within the zone of consideration?
My lord.
How the petitioner comes within the zone of consideration? Where are the amendments in the writ petition? Which paragraph? Paragraph number?
My lord, in the gradation list, my lord, the page.
Which paragraph of the writ petition?
Paragraph 8, my lord. There the petitioner has completed 18 years of continuous service as grade 4 staff of the office, and during his eligibility period, he applied for 3 times for his promotion, but authorities have not made any promotion in favor of him.
Maybe that is not a ground to interfere. You have to show that under the rules, this is the criteria. This many persons are to be considered. Your petitioner, your client comes in serial number so and so. He should have been considered, yet he has not been considered. Then only we can pass an order. Where are those statements?
My lord, subsequently after filing this order, my lord,
You see, Mr.
KU Ahmed, my lord.
Ahmed, unless the court order specifically deals with the issue, the entitlement and the right, you have seen what has happened, what happens. Orders are passed and then in 6 months you are back to the court. So there is a problem. This court will not pass that kind of orders. If you want that kind of orders, you wait, you will get it. You will keep going to and fro, that will go on happening. But if you want an order which is liable to and capable of implementation, then you have to give the right facts, right figures, and a proper order will be written down. Choice is yours, what you want. You can either wait and get something like that, where a vague order is passed, consider, they will consider and say he's not entitled. You come back again. Again, an order is passed, again you go, again you come back. This
My lord-
process will go on till your client returns.
I
That
have
is
come-
one way of doing
my-
things.
I have come against the order passed by the authority after.
No, but there is no pleading. There is no pleading. This is not, I want promotion, give me promotion. That's not pleading.
I'm just reading, my lord, there are 13, my lord. 13, my lord. Page 8, my lord.
Yes.
8, my lord. 13 and 14, my lord. That the petitioner states that after receiving the said order dated such and such, the impugned order dated 1/7/2019, whereby the case of the petitioner has been dismissed on the ground that the petitioner would be promoted only after promotion of the first person in the gradation list who possess all required minimum qualification as per existing government rules and guidelines. In the said impugned order, it is also stated that there were 4 vacancies available at the relevant period, which was already disclosed by the petitioner in the additional affidavit. My lord, subsequently, the petitioner states that Honorable High Court passed the order dated 30/4/2019, Annex 12, wherein there is clear direction to the respondent authorities to consider the case of the petitioner for promoting him to the post of LDA if vacancies were available.
Sorry, that's not the law. If vacancies are available, anybody and everybody cannot come and say, consider my case. This court will not pass that. You have to show me what is the criteria, what is the zone, how you come to the zone, what is your entitlement for consideration. Then only amendments will be passed. You don't have the pleadings.
My lord, 1 week time, my lord.
No, 3 weeks. That will be good for you.
My lord,
This kind of petitions, you will not get anything from this court. I had Mr. K.U. Ahmed and the counsel for the petition. And is granted 3 weeks further time to argue this matter. Mr. T.C. Chutia, learned additional senior government advocate Assam is present on behalf of the respondents. Mr. Ahmed, these are not petitions where promotion orders. It is like saying, I want promotion, give me an order, I want promotion. Something like children do to their parents when they to go to a shop. This, you have to make out a case on law and facts. There is nothing. Your only pleading is that I have worked for very long. There are 4 vacancies. So give a direction asking them to consider my case. This is certainly not a case where a direction can be issued. Certainly not a case.
Actually, my lord, they are not denying him his promotion. His second position. First position is to be yet to
That
be.
is the reason I am asking you.
Yes, that is-
Give me the facts and figures. How many people, what is the criteria? Who are the senior? What is the position? Nothing is mentioned. Only pleading is that I have worked for 18 years. There are 4 vacancies. Ask them
I
to
should be
consider.
promoted.
That can't be done. That's not the way it is.
After filing this petition, my lord, senior petitioner number, serial number 1, that employee was retired, my lord. Now I am getting the senior most position, my lord. I am filing an evidence, my lord.
Right.
Obliged.
These two are analogous matter pertaining to promotion, reservation in promotion to disabled persons in grade 1 and grade 2 post of the state. Now, the the Right to Disability Act provides for 4% reservation in promotion, in appointment to disabled persons. And the Honorable Apex Court has laid down the law in the year 2016 itself, that this appointment, irrespective of the mode, whether it is by way of direct recruitment or by promotion, the reservation of 4% has to be provided for disabled persons once the post has been identified. Now, in this case, the post we are concerned with is the post of assistant engineer. The petitioners are working as junior engineers, PWD. They are seeking
consideration for promotion to the post of
All of
assistant.
them come under the PWD category.
Yes, PW, that is not a disputed aspect. Now, the reason why they have been not been considered for promotion is that there is an office memorandum, there was, I should say, because that has been modified now. There was an office memorandum dated 7/1/2019, which provided that there will be no promotion, reservation in promotion for disabled persons beyond grade 3 and grade 4 posts. That means grade 1 and grade 2 posts, there'll be no reservation. Now, apparently that office memorandum is in conflict with the law laid down by the Honorable Apex Court, which is still holding the field. And now in these writ petitions, as it is, that was the obstacle in our way. We had challenged that portion of the office memorandum, and the Honorable Court on the day when the matter was moved on 1/9/2020 itself, the offending portion of the office memorandum was stayed. And despite that, we were not considered for promotion. And there were 2 batches of promotion which is affected during the course of pendency of these writ petitions. We were not. Now, after that, in the year 2022, 1/5/2022, sorry, 21st of May 2022, they came up with a modified office memorandum.
Where is that? Where is that?
That they have placed on record. Affidavit they have not filed, they placed it on record.
We are seeking, instruction from the personal department to give answer to her,
No, this will
So,
have to be sent.
at least 10 days may be granted,
Lordship, may I complete my submissions? The office memorandum, they have now modified it in accordance with the law laid down by the Apex Code. And now they say that as it is, the office memorandum comes in the year 2022, you will be considered for promotion now. But it is not a disputed fact that we were deprived of being considered for promotion only because of this office memorandum, which is apparently illegal in conflict with the law laid down by the Apex Code since its inception. And what is illegal is illegal since its inception. So merely because it has been modified in the year 2022. So our right does we had a right to be considered for promotion way back in at least from the day when the writ petition was filed, if not from the year 2019 itself. Now, just because you have modified the office memorandum now, we cannot be considered.
So they are all from the same department.
Yes, same department. 2 of them. There are 2 writ petitions, 2 petitioners. Yeah.
How many petitioners in total?
2.
Okay, they are seeking promotion to which post you say?
Assistant engineer.
Assistant engineer.
From the post of civil, from the post of junior engineer.
In the department of?
PWD department.
PWD.
Yes.
And some promotion process is on now?
Promotion process right now, I do not have instruction, but fact is that during the present proceedings, 2 batches have been affected and they were not considered. If your lordship kindly takes up the record of item number 21, WPC 3317 of 2020.
So therefore, the first thing is your clients will have to be considered for promotion against the 3% earmark quota.
Yes, 4% earmark quota for.
Is it 4% or 3%?
4%.
But the statute says 3%?
No, it's 4%. Prior, the earlier statute of 2005, it was 3%. 2016 statute makes it 4%.
So this 4% is to be calculated on what basis?
Lordship, as it is, this is horizontal reservation. So it has to be now the vertical reservation that has to also be, it cannot be simply stated that this must, but
4% is to be calculated on what basis? Sorry?
Cadre strength, yes.
So how many, what is the cadre strength of assistant executive engineer?
Lordship, I have provided some details here in my writ petition, but subject to what they have said, because we do not have the enough data on that point.
Mr. Nayak, any idea what is the cadre? Can't hear you actually. You have a mask and then. Yes.
That instruction I have to take, but so far as the present petitioners are concerned, I have been informed that they are under consideration,
They may be under consideration, but we don't want 5 more litigations to come in. Okay, everything happens in piecemeal manner, no? So first of all, how many vacancies are there in PWD category?
Yes, that instruction.
How many? with effect from which date this law has come into force.
Lordship.
If the law has come into force from an anterior date, then every time a person is not considered, have to be considered as a backlog vacancy.
Yes.
Lordship.
So say one each could have been appointed in 19, 20, 21, 22, then there will be 4 vacancies in PWD. The department will have to, personnel department will have to pave the way for that by notifying that these vacancies will have to be deemed to be carried forward. If that is not done, the court will strike down all promotions given to everyone.
Lordship.
You don't have any option.
Lordship,
The
my
law will,
submission- Yes.
just a minute,
Lordship.
please understand the issues. The law will take the course which it should take, is it not? If it is the edict of law that you have to earmark this many posts, and this PWD category is provided under a special statute, which is enacted as per the commitment of India in the Kyoto Protocol. Is that the Beijing Protocol? Beijing Protocol.
Yes.
So this has to be implemented in letter and spirit. There are Supreme Court judgments. Perhaps this court has also passed some orders. So it is not only about giving them promotion. If you do it wrong, you are going to create a massive mess. And if the scope and opportunity is there, it will be all reflected in the judgment. Because if the department does not understand these things and does in piecemeal manner, what it is doing is it is promoting more and more litigations. So now onwards, we have to write these things in the judgment. That is the reason I am telling it to you that while seeking instruction, please ask your officers to apply their mind and seek legal opinion on this. These are mandatory provisions which have to be complied with.
Yes, Lordship. But my only submission will be, Lordship, suppose the strength is 100, then 4 posts are reserved for PWD's, Lordship. If already 4 persons are holding the
Then
post,
they'll not
Lordship,
get-
then there is no scope for them, Lordship. That is one, Lordship. Secondly,
But
Lordship,
they have to be promoted or appointed as PWD category. Not that they come in as general category, but they had some disability. That will not work. Their recruitment promotion has to be on the basis of a clear identification of these vacancies, and they will have to be promoted as that, not on merit.
no, what I'm trying to emphasize, Lordship, just because I am a PWD, Lordship, it is not that you have to give me promotion. That will depend upon the vacancies, Lordship. If suppose 100 is the stand and 4 positions are reserved for PWDs, if 4 persons are already occupied,
That's
Lordship,
what
then
I'm
they
saying,
cannot
Mr.
be
Nayak,
promoted.
if these
Yes,
4 persons were promoted on merit,
Lordship.
but they happen to be PWD,
Lordship.
then you can't treat them as PWD category.
Yes, Lordship.
That is what, that is also what they have done.
You
So
can't
far
do
as
that.
my instruction goes.
You can't do that. And that will create a
And second,
thorough-
so Lordship, that is why the affidavit of the personnel department is required. Personnel department issued the notification only in the year of 2022, Lordship. Earlier, Lordship, there was no scope for promotion in class 1 post, Lordship. That right accrued only in the year
That's correct.
2022. Now, Lordship, whether that reservation will apply from the date of Supreme Court judgment or from the date of
Of
the
course, date
notification.
of
that
Supreme
your
Court
Lordship
judgment
will
is the
decide.
law, not your
Yes,
notification.
That
Your
was-
notification-
that affidavit.
Law is the Supreme Court judgment, not what you notify.
Yes, Lordship.
Notification is your guideline for your own purpose.
Yes, Lordship. Just being the administrative department, we are only following the OM of the personnel department.
You
That-
filed
that
your
affidavit
affidavit.
is-
That's why about 10 days time maybe.
No,
You send-
affidavit till, Lordship, we have provide some data here, we have provide some materials, that we are within the zone of consideration. Till date, Lordship, no affidavit.
But Ms. D. Burgoyne and counsel appearing for the writ petitioner in both these petitions submits that her clients belong to the physically disabled category and are entitled to consideration for promotion to the rank of assistant executive engineer against the 4% quota earmarked for the said category. Notwithstanding the same, and despite the fact that by issuing notification dated
21/5/2022.
21/5/2022,
Yes.
Yes, the later
the
notification.
government of
Modified.
Assam, personnel bracket A department has also accepted the said position of law no action has been taken for consideration of the case of the petitioners till date. First up, according to Ms. Borgohai, no incumbent in the post of Assistant Executive Engineer in the PWD Assam has till date been promoted against the 4% PWD category quota. Full stop. Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing for the personnel department, prays for and is granted 10 days time to obtain specific instruction responding to the above plea raised by the petitioners. Let this writ petition be listed again on 8/2/2023 as fixed items.
Obliged.
Item 22.
May I please? May I please, Lordship? We are directed to bring record, original record, Lordship. Some more time required. We have not
What
received
record of what? What is this?
the departmental
My
procedure.
lord, this is the input order passed by the departmental authority, madam, by which imposing penalty upon the petitioner for stoppage of 1 week increment without with cumulative effect. Madam.
She is in petitioner is in service.
Yes, still.
We'll give them, give her some time.
Yes.
How much time you want?
3 weeks.
Heard Mr. R. Islam, learned counsel for the petitioner, also heard Mrs. Burwa, learned government advocate Assam, appearing for the state, who submits that records of the departmental proceeding are not yet available with her, and therefore another 3 weeks time be granted for obtaining the record. Prayer allowed, this the matter accordingly.
Much obliged.
Item 24 and 25.
Lordship, I pay for adjournment of this matter. Today, my senior has some personal difficulty.
He wants adjournment. Mr. L. Mohan, learned counsel for the petitioner, has appeared and sought adjournment for 2 weeks on the ground that his senior is not available. The prayer is not opposed by Mr. P. Nayak, learned.
GMC,
Learned,
standing counsel James.
standing
GMC.
counsel GMC, appearing for the respondent. In view of the above, this matter stands adjourned for 2 weeks. Yes.
Item 26.
May it please your lordship.
These matters, huh? There are 2 cases.
My lord, the petitioner before your lordship is saying the inordinate delay of 8 years in issuing the memorandum of service to him. My lord, today, my lord, though the pleadings are complete, lordship, you kindly peruse the order dated 25/4/2022. This has not been complied with, my lord.
Order dated
25/4/2022.
Yes, I know.
Review the piece of application there. Okay.
Yes.
Lordship, in fact, so far as consideration of this case of promotion is concerned, he has to have the requisite qualifications to be considered for that. Now, as a matter of fact, Lordship, another WPC has been filed where he is seeking a promotion by the same person. But 2 years tenure as a commander is required to be considered for being considered for the next higher post, which he does not have. Now, how do
No, according to your petitioner, is not in the zone of
No,
consideration. Why is that?
because he does not have that 2 years qualification of.
Is that available from the pleadings on record?
So this is a different case. This is, he has challenged the DP. The promotion case in which he has challenged he seeks a promotion, that is lordship, I can give the number.
So I have communicated this order. They can inform me the grounds, my lord.
That of course we can do, but my instruction is lordship, if he has the requisites lordship, definitely that is another aspect of the matter. But he does not have that, and that is also pending before this court.
In another petition?
In another petition.
Yes, my lord. I filed another petition seeking promotion because my juniors were promoted superseding me. There is another petition pending. But my lord, that's why my lord, now I am entitled to be promoted. Now I am holding the post of superintending engineer, border road organizer. I am entitled to, according to me, I am entitled to promotion to the next high court, that is civil engineer. So my lord, this honorable court passed this order. They should hold the review to be seen.
I
No,
can
but
place that
you see,
by way of-
Mr. Patwari, the court has also said if he
Yes,
comes.
sir. If I am not eligible, am I not entitled to know the reason, my lord?
He already knows the reason because he has challenged that in the other eight
So
petition.
we'll say that you will communicate to him.
I can bring it on record by way of an affidavit in this case.
How much time do you want?
See, 2 weeks time I can do that.
Let him bring it on record.
Yes, sir.
Within 10 days. sir.
All right, heard Mr. J. Patwari, learned counsel for the petitioner, who submits that despite the specific directions contained in order dated 25/4/2022 passed by the court in the present proceeding, the case of the petitioner has not been kept in seal, considered and kept in seal cover.
No review DPC has been.
Huh?
Direction was to hold the
That
review
means that
DPC.
no review DPC has been held till today to consider the case of the petitioner for promotion to the next higher post. Responding to the above, Mr. R.K.D. Chaudhary and DSGI submits that the petitioner does not come within the zone of consideration, and that is the reason why his case could not be considered by the review DPC. Mr. Dev Chaudhary, however, prays for and is granted 2 weeks' time to bring those facts on record by filing an affidavit, and also indicating the reason why the petitioner was not found to be within the zone of consideration. Prayer allowed, let this matter be listed again after 2 weeks or as soon as the affidavit is brought on record by the respondents.
Development.
My lord, in item 27, I am appearing for the respondent number 1, and we have filed a reply affidavit day before yesterday. That is not on record, my lord.
I am body petitioner number 1. I am body petitioner.
So you have got the copy of the.
No copy has been
No,
furnished.
that reply affidavit is in response to the affidavit filed by the respondent number 2. Lordship, I was given the liberty to file that affidavit by the order dated 16/12/2022.
But you have to
So
give
the
him a
respondent
copy.
may be direct.
My lord.
furnish a copy.
My lord, I have given an undertaking day before yesterday. Nobody was in the court. I tried to get in touch with the counsel, and I have given an undertaking. Respondent number 2, I will give him a copy. So may I pray this matter may be listed along with another matter, 4861 of 2020. Similar issues are involved, my lord. 4861.
Yes, he may be directed to furnish a copy of this. Yes. fine.
I'm giving a copy right now, my lord. This is for him. I don't want to.
Yes,
This is for him.
yes, thank you.
Mr. D. Talukdar, is it? Now, counsel is present on behalf of the petitioner. Mr. S. Chakraborty, learned CGC. You are
No, my lord, for ONGC, respondent number 1.
counsel for the respondent number 1 submits that in terms of the leave granted by the court and an affidavit in reply responding to the affidavit in opposition filed by the respondent number 2 has been filed yesterday,
Day before yesterday.
day before yesterday, but the same is not on record. First up, Mr. Talukdar submits that he has not been furnished with copy of the affidavits filed either by the respondent number 1 or the respondent number 2. First up, the learned counsel for the respondent number 2, Mr. Huh? Would you understand?
Subrato Bhuya.
Subrato Bhuya.
Subrot Bhuya is the counsel on record, but what is your name?
No, it's all right. Subrat Bhuya. has assured, and Mr. S. Chakravarti, Learned Counsel for the respondent number 1 has assured that copies of the respective affidavits will be furnished to the petitioner's counsel during the course.
No, my
of the
lord.
day.
So far the reply affidavit is concerned, I have filed a
All
copy.
right, that's.
And
all.
the original affidavit in opposition, they have already having a copy.
I have already replied to this.
All right. In view of the above and on the request of learned counsel for the parties, let this matter be listed again after 2 weeks by tagging the.
On 20 of the February.
No,
On
20th,
20th February.
on 20th of February, 2023, by tagging the affidavit in the record of the case.
Along with my lord, another writ petition I have given.
Along with WPC number 4861 of 2020.
It would, I said. Before it meet with the lord. Well, in this matter, we have filed our additional affidavit in reply today. Well, there is another matter, similar matter, which also need to be tagged along with this matter. There is WPC 3964/2022.
What is this matter about?
No, this is with regard to allowances which has been withdrawn in gross violation of natural justice and withdrawn only in respect of Assam Agricultural University, Jorhat. So far as other centers are concerned, they were continuously giving this allowance, my lord. There are two allowances which are arbitrarily withdrawn from the
So
petition.
this is additional affidavit in reply.
No, affidavit in reply, my lord.
Affidavit in
To
reply.
the affidavit in opposition that has been filed today, my lord.
So you have filed a rejoinder.
Yes.
Against whose affidavit?
Against the affidavit filed by respondent number 1, 2, and 3, my lord.
You are appearing.
Yes, I filed affidavit for respondent number lordship 120 for what a respondent of RCR.
Have you received the copy of the rejoinder?
Yes, ma'am, I have given.
How many respondents are there?
There are 6 respondents, my lord.
And who are for 4, 5, and 6?
This is for the Assam Agricultural University, my lord.
They have a standing council.
They have a standing.
Assam Agricultural University.
All right, heard Mr. H.K. Das, learned counsel for the petitioners. Also heard Miss
JP Das, Jupiter Das.
J.P. Das, Miss J.P. Das, learned counsel appearing for the respond numbers 1, 2, and 3. None is appeared for respond numbers 4, 5, and 6, bracket AAU. Although the name of learned standing counsel is duly reflected in the cause list, Mr. Das submits that the affidavit in the rejoinder affidavit filed on behalf of his clients responding to the counter affidavit filed by the respond numbers 1, 2, and 3 is not on record. In view of the above, office to list this case again after 2 weeks by taking the rejoinder affidavit filed by the petitioners on
Today, my lord. We have filed it.
filed by petitioners today, that is give the day. Is there any interim order here?
No, my lord. There is another petition, my lord, identical, my lord, issue, WPC 3964. That is not, that has not come today, my
So
lord.
on the request of Mr. H.K. Das, learned counsel for the petitioner, let this matter be listed along with WPC,
3964/2022.
which is stated to be analogous to the present proceeding.
Deep.
Item 34.
In this case, now the affidavit is sent for vetting, my lord.
None appears for the petitioner. Mr. J.K. Parajani, learned government advocate Assam, submits that the counter affidavit on behalf of the department has been sent for vetting. And therefore, this matter be adjourned for 3 weeks so as to enable him to bring the same on record. Prayer alike. You are there, Mr. Nayak?
Yes, sir.
Mr. P. Nayak, learned SC.
PWD lordship 1 and 2.
PWD is present on behalf of the respondent numbers 1 and 2.
Item 35 to 39.
Mashika, these matters relate to interzone transfer of railway police, Mashik. I have received some instructions, Lordship, not ready, but I'm seeking 2 weeks for the time to file my affidavit. Lordship.
Yes, madam.
They are
2 weeks will not be
legal.
possible. 4 weeks will adjourn it. 2 weeks, many matters have been fixed.
I leave it to you. Lordship.
Learned counsel for the petitioners are present in this batch of writ petition. Mr. R.K.D. Chaudhary, learned DSG, I submit that he has received some instruction, but some more instructions are called for, so as to make complete submission referring to the merit of these writ petitions. On such count, Mr. Dev Chaudhary has paid for 4 weeks further time to argue these matters. Prayer stands allowed. You are there? Let this writ petition be listed accordingly.
Milord, interim order may be called.
Interim orders passed earlier to continue.
They are already working in the present place by virtue of court's order, Lordship.
Supplementary list for.
In this case, madam, I've got the detailed instruction, madam. I have to file. Instruction received.
You are for whom?
And for the shared respondent. madam.
Now, respond numbers,
All the respondents. madam. So, all the respondents.
so what is the matter?
Lordship, major punishment was granted to the petitioner, dismissal from service, Lordship, police constable, Lordship. If it is been verified.
Heard Ms. R. Chaudhary, learned counsel for the petitioner, also heard Mr. J.K. Parajuli, learned government advocate Assam, appearing for the respondents who submits that he has received written instruction and therefore be granted 3 weeks time to file affidavit. Prayer allowed. Let this matter be listed again after 4 weeks. In the meantime, affidavit on behalf of the respondents be brought on record by serving advance copy upon the petitioner's counsel.
Lordship, can it be possible after 2 weeks, Lordship, to already?
It will not be of any use.
No.
It will be after 8 weeks then, because 2 weeks he will again sit time and again he will go after. Give him some time.
Daily list for orders, item 14.
May please, your lordship, I am appearing on behalf of respondent number 1, 2, 3, and 4. Kindly allow some time to file.
None appears for the petitioner on call, Miss A. Begum, R. Begum, learned counsel for the respondent 1 to 4. Prays for and is granted 4 weeks further time to file affidavit. Let the matter be listed accordingly. Yes.
Item 41.
May I please, your lordship?
Yes. Yeah.
Lordship, matter pertains to promotion has been denied on the basis of uncommunicated adverse remark. So thereafter, in tune of Devdutt's case, this honorable court has directed to review the matter. So they have reviewed it on the. Yesterday, he has informed me over telephone that already they have reviewed it and keep it unchanged, the adverse remark.
Have you received a copy of this?
No,
order?
my lord.
When you examine it, then you make your submission.
Yes, please.
I heard Mr. B. Deka, B.M. Deka, learned counsel for the petitioner. Also heard Mr. R. Dhar, learned counsel appearing for the respond number.
My lord, 2 and 4.
For numbers 2 and 4, who has produced a copy of the order dated 15/11/2022, issued by the Chief Executive Officer, Assam Khadi and order dated 29/11/2022, issued by the Under Secretary to the Government of Assam, Handloom, Textile and Sericulture Department, to submit that in terms of the court's order, the petitioner's case was considered but rejected due to the reasons stated therein. Mr. K. Munir, P.K. Munir, learned counsel is present on behalf of
2 and 3.
respond numbers 2 and 3.
It will be for me 1 and 4, man. 1 and.
R. Dhar for 1 and 4. Mr. Deka, however, submits that he is not yet in receipt of copy of the order dated 29/11/2022. In view of the above, a copy will be furnished to Mr. Deka during the course of the day, so as to enable him to examine the matter and make further submissions. Let this petition be listed again after 2 weeks.
Much obliged.
Item 14.
The matter relates to non-payment of retirement benefits.
My lord, I have newly engaged, my lord. Today I have filed column number for the sole respondent, my lord.
Mr. A. Bhattaji, learned counsel is present only the petitioner. Mr.
B. Sharma, my lord.
B. Full name, please.
Bankim Sharma, my lord.
Mr. Bankim Sharma, learned counsel, has appeared for the sole respondent and submits that he has filed his wakalat number today only, and therefore, how much time?
My lord, 2 weeks,
2 weeks.
4 weeks, my lord.
4 weeks time be granted so as to enable him to obtain instruction and file affidavit if necessary. Prayer allowed, let the matter be listed accordingly.
Up to 48 minutes, similar.
You are appearing for all of them.
My lord, my lord.
Same order up to 48.
Multiply.
But in this case, I am instructed to appear for all the respondents.
Hmm. Yes, why the court order has not been complied with?
Lordship, in fact, the deputy commissioner asked the magistrate to make an inquiry, and SDO to make an inquiry, and SDO has made an inquiry, Lordship. Inquiry report is there. But Lordship, I have seen the inquiry report. He has could not come to a conclusion, Lordship, regarding the date of birth of the petitioner, Lordship. Lordship,
Then, what is the direction?
Lordship,
Relevant by the page 20, madam. In contempt petition.
Page 25.
Page 20. Paragraph 6.
The inquiry on what?
Inquiry, the effect, Lordship, his date of birth, actual date of birth, Lordship. There is, Lordship, confusion with the dispute with the date of birth of the petitioner.
So they have made an inquiry. That's the only order to
Lordship.
make an inquiry. The inquiry has been made.
Inquiry has been made, Lordship.
Now what?
My lord, they have to, my lord, come to a conclusion, my lord, what,
Where is the
Yes,
order?
exactly, no order is there, Lordship.
but my lord, they should file an affidavit, my lord. So,
No, there is no direction. What to do? Contempt is a serious business. Heard Ms. R.S. Deori, learned counsel for the petitioner, also heard Mr. N. Upadhyay, learned counsel, appearing for the
all the
respondents who submits that in terms of the order dated 24/1/2022, an inquiry was conducted through the
To the Lordship Subdivisional Officer, Gwalpara.
subdivisional officer Gwalpara, and a report has also been submitted on
It is submitted on Lordship. 20.
dash dash dash. According to Mr. Upadhyay, even after the inquiry, no conclusion could be reached as to the date of birth of the petitioner. However, since the only direction in the order dated 24/1/2022 was for causing an inquiry into the matter, no further action has been initiated by the authorities. You have received the copy of the inquiry report?
no, my lord.
I'll give you. I'll give you.
A perusal of the order dated so and so prima facie establishes the claim of the learned counsel for the respondent. Full stop. Ms. Deori submits that she has not received a copy of the inquiry report. Full stop. After examining the inquiry report, if the petitioner petitioner claims any further relief in the matter, then the way forward would be to file appropriate petition seeking further relief and not in this contempt case. First step. Since it is not a case of willful disobedience of the order of this court, I do not find any justifiable ground to continue to keep this petition pending. The contempt case is accordingly closed. Yes. So that's it. We'll come. What is the next item? What is orders?
May I please, your lordship? Lordship, 2 weeks time may be given for filing affidavit in reply. Lordship, affidavit of opposition filed by the respondent number 2.
Letter number
2.
Mr.
PJ Datta.
PJ Datta, Direct Counsel for the petitioner pays for and is granted 2 weeks time to file rejoinder. Responding to the counter affidavit filed by the respondent number 4.
2.
Respondent number 2, Ms. S. Burwal and Government Advocate Assam appearing for the
1 to 5.
respondent numbers 1 to 5 is present and does not have any objection. The prayer is over.
Obliged.
Yes.
Item 51 to 55.
In this case, I am appearing on behalf of the APSC, my lord. I'm sorry, my lord, I earlier also have taken time. My lord, already affidavits are ready in these 5 cases, my lord, they are interconnected. So let me 10 days time, my lord, I'll be finalizing that. Within 10 days, my lord. Because, yes.
My lord, last date in the honorable court had instructed that a composite affidavit may be filed. Like taking into consideration all the read petitioners, like there are a number of read petitions in connection with this matter. So if a composite affidavit is filed, then our contentions will be also taken care of. And
What are these matters?
Absolutely correct, my lord, and what says, my lord. In the meantime, my lord, one of the coordinate branch, my lord, passes judgment in respect of the similar matter in another department. These are regarding qualification, my lord. Qualification, my lord, diploma in civil engineering and planning, whether it should be treated as the same or not. So in one matter, my lord, this honorable court already passes judgment. So you sit together with the department, because we cannot, APC cannot compare with the technicalities, my lord. So you sit with the department and with the director of technical division, take a decision. That judgment was passed. So very recently, my lord, last week, my lord. So in view of that, my lord, we try to sum up everything, my lord, all the department to start to find out a solution, my lord. That's why I'm taking time, my lord. So,
All right, now,
within 10 days,
these matters, what appointment?
yes, my lord, it is regarding the advertisement which was published by the APSC regarding filling up of 307 posts for the position of junior engineer civil in the department of PWT.
already stay
So already in this
already they are protected because
We are
some post has been.
All right, heard Mr.
WR made.
W.R. Medhi, Learned Counsel, you are appearing all the cases.
Lordship, I am appearing item number 53, Lordship. Item number 53, Lordship.
Appearing item number 52, 51, 52, 54,
I am appearing for 51 and 55.
which are 51 and 55, and Mr. DJ Das, Learned Counsel appearing in item number
53, your Lordship.
53. The Learned Counsel for the petitioners in the other cases are not present. First up, Mr. TJ Mohanto, Learned Senior Counsel, assisted by Ms.
P. Sharma,
P.
Lordship.
Sharma, appearing for the APSC, submits that although the composite affidavit to be filed in all these cases has been prepared, yet there has been some recent development in the matter which would require recasting of the affidavit. Therefore, 2 weeks further time has been prayed for by the Learned Senior Counsel to bring the affidavit on record. Mr. P. Nayak, Learned Standing Counsel PWD is present and does not have any objection to the prayer is allowed. In view of the above, let these matters be listed again after 3 weeks. The affidavit on behalf of the APSC be positively brought on record within 2 weeks by serving advance copy upon the Learned Counsel for all the petitioners.
Obliged.
56 and 57.
My lord, here, my lord, I am representing item 56. My lord, post of Anganwadi worker. My lord, here, my lord, item 57, I am appearing. We have taken steps, my lord. Notice was issued on 9/1, and we have taken steps, my lord. Let it be, let the department collect the instruction on that.
Yes. You are appearing in which case, Mr. Bushra?
My lord, the second case, my lord, item 57.
And 56 is for.
He is appearing.
What about?
In both the cases, notice were issued on 9/1.
But service report is available.
My lord, I am claiming that I am working in the Anganwadi helper since 2007. I am entitled to be promoted since I have completed 10 years and I have also appeared in the SLC examination. On that strength, I am claiming as per the guideline. So that my friend client is claiming that she is also worked in the Anganwadi worker force. So in that context, my lord, the report of the government is necessary. Who is working?
Instruction awaited, Lordship.
You have taken steps on private respondent. Who is the
My-
private respondent?
No, on government, my lord. Official respondent.
Take down. Heard Mr. A.R. Sikdar, learned counsel appearing for the petitioner in item 56 and Mr. G. Boysal, learned counsel for the petitioner in item 57. Full stop. Also heard Ms. S. Borwa, learned government advocate Assam appearing for the state who submits that instructions as called for in these matters are still awaited and therefore she be granted
3 weeks time.
3 weeks further time to obtain instruction. Prayer allowed. Let these matters be listed again after 4 weeks. In the meantime, the learned departmental counsel to obtain instruction.
Leave love.
Item 58.
Call somebody else to change also.
May I please the lordship? My lord, the notice was issued and my lord, we have taken steps, my lord, on response number 3, my lord, and government was supposed to file affidavit and instruction, my lord. The petitioner is against his transfer order, my lord,
You have taken steps on whom?
on the response number 3, my lord. Registered post as well as by dusty service, my lord.
So your affidavit, you filed affidavit.
Yes,
after
my
this?
lord, I have filed it today, but it has not come out.
Mr. D.P. Vora, learned counsel for the petitioner submits that after taking steps for service of notice upon the petitioner upon the respond number 3, the registered post with AD as well as by dusty service, the petitioner has filed an affidavit today, but the
Today,
same is not on record. Mr. T.C. Chutia, learned additional senior government advocate Assam appearing for the respond numbers 1 and 2. Submits that he is yet to receive instruction in the matter. Full stop. In view, you are for 2. Mr. S. Datta, learned standing council, revenue and disaster management department, Assam, appearing for respond number 1 and so and so for 2, submit that they are yet to receive instruction in the matter. And hence pray for how much time?
3 weeks left.
2 weeks for, huh?
2 weeks left.
2 weeks further time to obtain instruction. Prayer allowed, let the matter be listed accordingly, along with the affidavit filed by the petitioner today, that is, give the date.
Extra copy not furnished.
I'll furnish it today. My lord, interim order passed earlier. maybe continue.
Interim order passed earlier to continue. What is the interim order?
Stay of the transfer order, my lord. Oblige, my lord.
Item 59.
May I please, your lordship?
Yes.
Can is the page number 11, my lord? Page number 11, my lord.
Yes.
My lord, petitioner father's name is wrongly typed, my lord. Kindly see the paragraph number 2, my lord. Paragraph number 2, my lord. The father of the petitioner, Mezazuddin Ahmed. But it's wrongly typed, my lord. The correct name is the Mezazuddin Mozumdar, my lord. The simple correction, my lord.
So the learned judge is available. Let it be listed on Monday before the appropriate bench. Correction. Judge is available. By filing this application, a prayer has been made for correction of an order dated, correction of a mistake in order dated 14/12/2022, passed by the learned single judge in WPC number 8028/2022. First up, since the learned judge who had passed the order is available in Guwahati, hence I deem it appropriate to direct the registry to post.
My lord, may be listed on 3rd February, my lord.
Huh?
May be listed on 3rd February, my lord.
Before the appropriate bench. Mr.
S. Rahman.
Mr. S. Rahman seeks posting of this matter again on 3
February.
2023. Mr. D. Upamanu, Learned Standing Council, Health Department, Assam is present and does not have any objections. Register to list the matter accordingly.
Highly obliged.
Supplementary list for orders, item 62.
Also, on the last occasion, we are asked to take steps, Lordship. According to we have done so now.
Steps for issuance of notice upon whom? You are appearing for whom?
Or respondent number 2 to 5. What is the submission on 16/12/22? There is an order. I am concerning with the interim part of the year, last operation charge. Because here, the appointment of the respondent number of the state.
Mr. Das, two proceedings cannot go on here. So, because there is a acoustic problems here, I'm not being able to follow. Yes.
So this is, by this order, the appointment order has been stayed, but appointment was made by 2021. So that is because 16/12/22, this is the order. So already appointment has been made prior to this 1 year back, that is 27/12/21. So here, because there is an order by this court, by the next January, it is expected that the authorities in the IOC, as well as respondent number 6, would make their stand clear before the court by way of their respective. Sorry, today I could not file the affidavit, but this is the document that she has joined on 27/12/2021. This is the joining date.
Simple. 2021. Appointment. Sign on. Oh, 22, sign on. Okay. Orders, 27.
27.
So respondent number 6 has already joined.
Already joined. That to 1 year back.
So what do you have to say on this 27/12?
Lordship, may bring this by way of an affidavit, Lordship. Lordship may fix a early date, Lordship, next week, Lordship.
Why should we fix it next week?
Lordship,
Why?
can bring it to an.
There are thousands of cases where other important cases. Why should we fix it next week?
Because we have to take instructions from our client also, Lordship.
We will go by what we think is urgent and what.
Lord.
What is the urgency in this case? Your client he was not selected.
Because Lordship, that 5 years election period was not granted to him, otherwise he has secured higher marks. But for the age election part, otherwise he will be selected. You challenge that, Lordship.
Take down Mr. N. Gautam Nanak Council appearing for the petitioner who submits that steps for service of notice upon respondent numbers 2 and 6 have already been taken. Full stop. However, this said fact does not find reflection in the office note. Be that as it may, Mr. H. Rahman, Learned Senior Counsel, assisted by
Ms.
P. Agarwal.
P. Agarwal.
P. Agarwal, and
Ms. T. Singh.
one will be enough.
My lord, actually.
Huh?
Ms. T. Singh.
Ms. T. Singh. All right, is present on behalf of the respondent numbers 2 to 5, Mr. B. Fukan has appeared on behalf of the respondent number 6. The learned counsel for the respondent submits that the respondent number 6 was appointed more than a year back, that is on 27/12/2021, and he has since joined the service. As such, the interim order dated 16/12/2022 was obtained without placing the correct facts before this court. Be that as it may, Mr. N. Gautam submits that once the aforesaid facts are brought on record in the form of an affidavit, the petitioner will file suitable reply. In view of the above, this matter stands adjourned for 3 weeks so as to enable the respondents to file affidavit bringing the aforementioned facts on record. In the meantime, registry to we have taken steps. Registry to verify as to whether service of notice is complete on all the respondents and put up a note. All right.
All have appeared on the video.
All right.
All are.
Who is for respondent number 1?
Union of India.
Achha, then in the meantime, who is for Union of India? Ms. S. Burwal and CGC is present on behalf of respondent number 1. Since respondent numbers 1 to 7 have already entered appearance in this case, this matter is deemed to be ready as regards service. This case for admission after 3 weeks. In the meantime, parties to exchange pleadings. After 3 weeks. He is continuing in service. Respondent number 6.
Production progress item 1.
Make the note. Okay, the petition has filed challenging the OM that is given by the government. In this particular case, they have this honorable court has passed an interim order on 25/1/2023, referring the not to declare the result of the DPC. My case is the one post of citizen is going to be filled up by the DPC. 3% in the zone of consideration, and the gradation list there are 3%. 4% come under the zone of consideration, including the petitioner and myself. Zone of consideration is 4, 1:4. He's also zone of consideration, I'm also zone of consideration. DPC already held. Only thing is the DPC have to consider the merit. There is no question of seniority, there is no question of other criteria, only merit. So merit, he is also zone of consideration, I'm also in the zone of consideration. DPC will consider on the basis of merit. So if DPC is also the OM, nothing is affected in this particular case by the DPC. DPC will only consider the merit. Because post of citizen is on the basis of merit. Lordship has already passed an order in earlier petition.
Which order has been given to you?
Lordship will find page 20 order. Page 20, 22 is the directive.
Yes.
Considering the facts, circumstances, the case, entity, the way of interim measure, we hereby provided the order of final promotion, the post of civil engineer in the Department of Water Resources Department government shall be issued as per till next day. Shall not be issued. Now, Lordship will I take the Lordship to the the gradation list at page 16. Yes, page 16 is the gradation list.
Page 16 of
this I Lordship. Which is under selection.
Yes.
Gradation list, Lordship, I am serial number 1, 2, 3. I have joined on 86 and respondent petitioner has joined in 1992, Lordship. I am senior to him, 6 years senior to him. Only because he got accelerated promotion, he was promoted to the post of additional civil engineer earlier to me. After that, I have been promoted. Now he selects the gradation list. Gradation list has not to play anything in the selection process. Because for one post of civil engineer, 4% come under zone of consideration. He is also under the zone of consideration. One post is lying vacant. 3% will come under zone of consideration. And merit will be the only criteria. No seniority, nothing. They are challenging the seniority position.
Where are the rules? Which rules are applicable here?
Rules in Lordship, Water Resources Department service rule.
Let us see the rules.
Lordship, I can produce it, Lordship. Only they also have it, Lordship. Only merit is a criteria.
No, but you are and they are aware, will becoming aware, the
Lordship,
court
can-
also wants to be aware.
Lordship will kindly see earlier DPC, held in my case, Lordship, I have enclosed the DPC, where DPC has categorically stated that merit is the only criteria. I have enclosed the DPC, earlier DPC for the post of promotion of the superintendent. I have enclosed that, Lordship, page 12. Page 12 is the DPC, the earlier DPC. Well, Lordship, Odujoti Das, 16.
Page of what?
Page 13.
13 of car petition.
My petition.
Yes.
And on the basis of merit, Lordship, person has been recommended for promotion. In earlier DPC also. Same formula also. The standing council of the water resource department is there, Lordship. They also aware the service rule that only criteria is merit. Lordship, I'm sorry, Lordship, I could not bring the, hurriedly we have filed this petition, we could not bring on record the service rule, but the service is that, Lordship. And secondly, Lordship will kindly consider one thing. In water resource department, another councillor, he has filed another petition, wherein Lordship has passed, the promotion is subject to the result of the case. Same department, same team, Lordship has earlier passed an interim order that promotion is subject to the result of the case. I'm not objecting to that, Lordship. If promotion, I'm qualified in the DPC, I will be promoted. If I'm not qualified, I will not be promoted. Promotion will be subject to the result of the case. And if he is recommended, he will be promoted. If I am recommended, I will be promoted on the basis of merit. That is a simple and substance case also. Because there is no law point involved, only criteria is merit. DPC will consider merit. Among the 3 candidates who will get the merit, he will be selected. He will be promoted. So merit, in this particular case, nothing, Lordship, OM is not considered, seniority is not in the not to be considered. Only the merit is to be considered. On the basis of merit, it will be decided. Lordship will finally decide it. They have challenged the OM. Clause 4, 5, 1A, they have challenged. That will be decided by the finally by Lordship regarding whether OM is legally sustainable or not. Clauses of the OM is legally sustainable or not. Only in this particular case, Lordship, I am going to retire on Monday.
All right. Yes, who is appearing for the department?
That's what we have to do. We have to do.
What do you have to say on his application?
Lordship, this gradation list was prepared as part of OM of 18/1/2023, Lordship. That according to the merit, Lordship, petitioner, the present petitioner is senior. Means he is eligible for that. Lordship.
No. Who are the, how many candidates have been considered?
3, Lordship.
Who are these 3? That does that include the writ petitioner also?
Lordship.
Writ petitioner has also been considered. And the 2 private respondents in the writ petition, all 3 of them have been considered.
Lordship.
And the criteria is merit.
Merit.
All right. Yes.
And Lordship has already passed an interim order in same department.
That you have said. Please take.
Well, first of all, I'll come to your Lordship's order. The government advocate has not, I'll come categorically, the government advocate has not placed correct facts before the court. Because yesterday your Lordship's order was very clear, interim order. Your Lordship, I came to this court because I was all along on top of the list. And I made a specific averment that this OM thing, which I challenged on the earlier day, has nothing to do with my case. The rules have been violated. Now, your Lordship passes an order. This is a very serious matter. Again, I'll show it. Your Lordship will take up, your Lordship will take your the order dated 25/1/2023. If I may read it again. Assailing the provisional gradation list circulated in 13/1/2003 pertaining to the post of Assistant Chief Engineer in the Water Resource Department, Assam, for the year 2022, this writ petition has been filed inter alia contending that although the petitioner was all along placed hired in the private in the cadre of Assistant Civil Engineer, but all of a sudden his seniority has been downgraded without any reason, and now the respondents are contemplating to hold the DPC today.
itself to promote the petitioners junior to the petitioner, and 7 and 8, they are junior in the cadre. Your lordship will come below. The standing counsel, Miss Gogoi, she takes notice, so they are aware. Nat takes notice, aware. Your lordship will come next. In view of the request made by the learned departmental counsel, I am inclined to grant time till 1/2/2023 so as to enable to obtain instruction and clarify the matter. But the clarification was, your lordship specifically say, what is the reason you bring him down? You just clarify that one. However, such instructions are obtained if such the petitioner will render instruction. The petition, because I said that they will go ahead. What they did, at 2 o'clock, your lordship passes an order. And at 4 o'clock, 4:30, I get an information that they have already started the thing because, Malala, I'll show documents. No communication was sent by the standing counsel, whoever was there. They did not send it. Oblivious of the, because it was a very contentious issue, I told my clients to write a letter informing the chief secretary because he was the committee member. And your lordship will feel a seriousness. Malala, this government is thinking that they are above the law. But somehow they have kept one point. They didn't know that I have also taken steps. Your lordship will see. At 5:30, I immediately tell my client, you dash off a letter to the secretary. If I may read that. I have the honor to inform you that today, the Honorable High Court had passed an interim order in connection to the above mentioned case at reference above, restraining the government authorities not to proceed with the promotion.
That's a completely wrong thing. That's a completely wrong representation. Where is that order not to proceed?
Last name.
Where is the order not to proceed?
Yes, this is the order. It's hereby by an interim, it's hereby provided no final orders of promotion.
That is different from proceeding.
Malad?
Not to proceed, that order has not been passed by the court.
Not to because if the effect is given, if they decide the matter, then why was instruction called?
That is a matter of
leave of the court.
That is a matter of interpretation.
Yes, but your lordship did not. Usually orders are passed without the leave of the court. Your lordship says that instruction may be obtained. Now, what I personally want to say, that the meeting was held and I informed them that since the order was there, you do not pass it, and the petitioner now files a petition for vacation. He has a right to file a vacation. He admits that I have come to know that no order was communicated. Well, who is he? First of all, he's a respondent. He knows everything. Secondly, the gradation which I had argued, that final gradation list was not given to me. Neither it was communicated through other source. I got it. Your lordship wanted to know that representation. I read that representation. Here they say on a holiday, they pass the final gradation list. So basically, what was the hurry? You don't give me, but on a holiday, you come and you are prepared to proceed. Well, the standing counsel just now said it has been done in terms of OM of 18. Well, oblivious of the fact, possibly has not read my petition.
Your client's case has also been considered.
No, I did not. My case, I did not want a benefit of 18 for the simple reason. As I go on merit, that was my specific case. They say today they have said they have gone on 18 because we have the power to do it. The gradation.
Mr. Das, you say, let us address the main issue.
Yes, the main issue.
Please. Your contentions may be this, your contentions may be that, but you wanted an urgent order staying the notification of the promotion.
Yes.
The reason is that you have been downgraded.
Yes.
Correct.
Yes.
Now, Mr. Goswami is saying, and we'll ask from Mr. Majumdar also. They are saying that amongst the 3 or 4 departmental candidates who were considered,
yes,
your client is one of them. Is it? Is that correct?
Yes.
1 minute.
He says, how he knows I know.
And secondly, the criteria for promotion is only merit. So if that be the case, why should that interim order be continued? Because particularly when someone is saying he's on the verge of retirement.
Interim order was on till first.
How do you stand to benefit? That's what
the thing is that the minutes of the meeting they have held, they don't give me access. The minutes has to be placed. The government will have to file their affidavit. Why? I'm ready for hearing. Why is that your lordship will vacate the order within 48 hours?
You put a bond of 50 lakhs that if you don't succeed in this case, then he will be compensated. How do we give him the benefit if his client ultimately ends up being selected?
Then lordship,
He will have retired.
yes, then one thing your lordship can say that on Monday, I am ready with the case. Let the records be placed, affidavit filed on that day, because that is his possibly last day. I am ready for that. Without hearing, your lordship will not pass any. Monday I am ready. That will be better, lordship.
Mr. Majumdar, can you tell us whether
Let the record be.
the writ petitioner was also considered? And is the criteria only merit?
My lord, first of all, as your lordship has just now seen the very interpretation of your lordship's order by the petitioner, I'll say, I don't know who has written the letter, writing it to the department that you should not proceed is itself a violation of the court's order and it's a contempt. My lord, I'll come to that merit of the case later. My lord, if I out of enthusiasm, I think that the interim order passed by your lordship is not to proceed. Lordship may just kindly have a look at the order. Your lordship is indicated. I'm just reading once again. It says the operative part of the order, considering the facts and circumstances of the case in its entirety, by way of an ad interim measure, it is hereby provided that no final order of promotion to the post of chief engineer in the Department of Water Resources shall be issued by the respondents till the next date of next week's census. And the very use of the word final means you should not issue the final order of promotion. But so far as the proceedings of the DP is concerned,
Absolutely.
it is allowed. Well, in a tender matters also, a lot of often passes an order saying they don't find the final order because the tender process will continue. But final order of issuing the work order will not be done. This is the meaning of the word. Now, if the petitioner out of his enthusiasm writes a letter to the department, don't proceed. Why should the department follow this letter? And now the letter is being shown that I also have written not to proceed, as if he is passing the order, additional order, on top of the order passed by your lordship. This is not done, my lord. This is petitioner may have so many prayers in the court, but whatever order is
All right, that's taken. Now,
this is the first part.
yes.
Second part is, my lord, the lordship may kindly turn to page 13.
Page 13 of what?
13 of the IA, my lord, file for vacating the interim order.
Hmm.
Possibly this is the rule. I don't have a copy of the rule. I have asked my learned friend to get a copy. Possibly the criterion for promotion is mentioned here. Page 13, second paragraph, my lord, after the table. As per rule 13.4 of the Assam Engineering Flood Control Department Amendment Service Rules 1990, as amended, the selection of officers for promotion shall be on the basis of merit with due regards of seniority. Is that correct?
Now only
Now, my lord,
civil engineer to merit to executive.
okay, this is for executive engineer, chief engineer with the merit for things. My lord, if the criteria is only merit, my learned friend has challenged the petitioner.
Can somebody get the rule? Without seeing the rule, I will not pass any.
My lord, possibly it is necessary. They should get the rule.
I will produce the rule.
Without the rules, I will not pass
My
any.
lord, we have rules. Possibly we can get.
Just before I rise, if you can.
Just I will produce. My lord, my submissions are very simple on merit, my lord. Pursuant to the OM of 18 January 2023, fresh gradation list has been prepared in respect of the post in question. And I am told by the learned counsel for the department that prior to that, there was no gradation list. My learned friend will be knowing. Anyway, if there are only 3 persons who come within the zone of consideration, even without or even prior to the preparation of the gradation list based on that OM of 18.1, then the question remains, even without the new gradation list, all of them come within the zone of consideration because 1:4 under the rules. So even if the OM which they are challenging and the gradation list prepared on the basis of them, they are challenging, even without that, he is junior to him or he is senior, but then all of them come within the zone of consideration. If all of them come within the zone of consideration, my lord, and if the criteria is merit, then the OM.
No, if it is merit, then fine, but what is the criteria? That's what we are asking.
Merit also. I will place that. Here, see, he is also not dodging. Merit is the criteria. He also submitted in the
my learned friend is not objective.
repetition also very close.
But as you go upwards, the selection post.
No, for chief engineer, what is the criteria?
The chief engineer.
Possible penalty with petition, paragraph number 8.
I've already averred. It's a merit based. Only the thing is that with the seniority will also not be ignored for the simple reason that my entire case was I was downgraded without any cogent reasons. And your lordship fixed it on the day, next day to ask that question. Now, since I have agreed that on Monday, I am ready. Let the minutes be placed. What is there? We place and we'll make a
Lordship,
submission and whatever is.
They have quoted the rule in paragraph page number 8 of the petition. Merit is
No, I'm not.
they have quoted the rule. Lordship. Rule is quoted by him. Lordship.
I keep it because I was downgraded.
He has quoted the rule in the petition.
Yes.
And is it
My lord.
correct that the applicant is retiring on 31st of
My
January?
lord, I am told.
Yes.
Yes. My lord, I have got,
So on
my
Monday.
lord, my submissions are very clear. Lordship, may kindly have a look at page 8 of the writ petition. Page 8 of the writ petition, it's there, man.
Yes.
Page 8, rule 13 has been quoted. And just the paragraph above the bottom paragraph, my lord, all other promotions to the rank of superintending engineer on merit only. Is it? Is that the- if this is the rule, my lord, if the merit is the only criterion, then preparation of a gradation list, making him junior to another person, but coming, all of them coming within the zone of consideration, this additional advantage, if any, because of the OM of 18/1/2023, the present applicant has got by virtue of this consecutive seniority, that has not given any benefit in the TPC, because all of them come with the zone of consideration. And am I clear, my lord?
Absolutely.
Yeah. And thirdly, my lord, if the person is retiring on 31st, 2-3 days in as a special matter, possibly, my lord, I leave it. I'm not in favor of any of the person. I'm for the government. If he is retiring on 31st, let him retire as a
Page 16, Lordship, my date of retirement is 16.
because even otherwise, my lord, even otherwise, your lordship will not enter into the merit of the proceedings of the DPC. All that your lordship, before your complaint of the writ petition before lordship is that I am challenging the consequential seniority OM and the consequence order of preparation of gradation list prepared on the basis of that consequential seniority, not giving consequential seniority to this rank of officers. Then, my lord, the question arises, even if the benefit of consequential this catch-up theory is not given, his position qua the petitioner remains the same, because all of them come within zone of consideration. Even if they ultimately succeed, my lord, even if the writ petitioner ultimately succeeds, the proceedings of the DPC on this ground cannot be set aside, because all of them come within zone of consideration even without this fresh gradation list. Or what remains is the merit. If on merit he has gone, if he is not challenging his promotion on the basis of merit, possibly he has no case against the applicant. Very clear.
I'd like to add that he cannot presume that first I'll have to know what was the minutes. Because I have come to the court
on
on the minutes if they bring it, because basically they know, and the funny part is that the petitioner knows that his position is there or not. Possibly they've seen the selection.
No, Mr. Das,
Now, what I want
just a minute, Mr.
Yes.
I am requesting you to please consider a little minutely what is coming from the court. Because the court is also very minutely considering and weighing the pros and cons. And the court doesn't want that the counsels for either parties should not get a proper opportunity to respond to the queries. Of course, what order the court will pass, that is always up to us. We can always pass it.
Right.
But this court is particularly concerned that the learned counsel for all the sides must get absolute opportunity to respond to the queries. That is the reason I am requesting you, otherwise no other reason. You see, Mr. Das, your case projected in this writ petition, forget the other one, is primarily on the basis of downgrading of your client in the seniority, intersessional seniority. The procedure may be wrong, the procedure may be based on the impugned OM 18(1), etc., anything. The court has noticed that there has been some kind of a downgrading, prima facie. Correct?
An instruction was formed.
Yes. Now, the interim order became necessary as per the petitioner because there was an immediate move to promote a candidate to the rank of chief engineer. So the apprehension was that you will be left out from the zone of consideration. Correct? Now it transpires that you have not been left out, number one. We'll record it. If whatever order we pass, we'll record it. Listen,
I'll
listen.
make my submission.
Second thing, the criteria appears to be entirely on merit. Correct. It may so happen that your client may not be promoted for good or bad reason. It may so happen.
Only after seeing. Only after seeing the minutes I'll come.
That's right. That's right.
Because in other proceeding, after seeing the minutes, I
Correct.
can have a right of challenge.
But the applicant's case is that his client, he is retiring on 31st of January. So assuming that on merit, the criteria selection falls on the applicant. Even then, he can be in office at best till 31st of January. On 1st of February, the matter is still open. Yes. Correct. If he is the selected candidate and the stay order is continued, then even if he is selected and ultimately the writ petition is dismissed, he is deprived for all times to come. He doesn't get promoted. Correct. And why? For a court order. Correct. But if he succeeds and gets the promotion, even then the matter comes to square. It comes to the back to the square again on 1st of February because he is going. If any other candidate, there are two others besides you. You may be also promoted. You never know. You are assuming.
No,
You will know.
till the time I get the minutes. Because they have not given me.
So
the
therefore,
quotation,
at
they're
this
not giving the
stage,
minutes also.
as you know, certain things are not clear. And the court never state the process of whoever is written this letter has done a very mischievous thing. This is not
I will
done.
not vouch for it for the simple reason. The
No.
additional advocate general has rightly said the selection has been done and everyone has been brought into.
Correct.
Now, as a petitioner, do I not have a right to have the minutes? Because in the minutes.
That's a different thing. Who is saying?
That is another thing.
So that is the reason, Lordship, on 1st, it was there. I'm giving it to.
All right.
Since on 30th, I want that the matter should be finally.
Okay. All right.
I should also
Heard
be
Mr.
given a
S. K.
chance.
Goswami, learned counsel appearing for the applicant. Also heard Mr. D. Majumdar, learned senior, your senior additional AG. Is it?
Senior what is not there.
Additional Advocate General Assam, assisted by Mr. R. M. Das, learned counsel appearing for the opposite party numbers. Who are the opposite parties here? Opposite party numbers.
One is State of Assam.
1, 2, 4, 5 and 6. Mr. R. Dhar, learned SC, WPT and BC for OP number 3. And Mr. D. Das, learned counsel appearing for the OP number 8 bracket read petitioner full stop. This IA has been filed by the applicant Arup Jyoti Borthakur with a prayer to vacate the interim order dated interim order dated 25/1/2023 passed by this court in WPC number 405/2023, whereby the respondents were restrained from issuing any final order of promotion in respect of the post of chief engineer in the Department of Water Resources, Government of Assam, until the next date fixed, that is 1/2/2023. Full stop. The basic grievance of the writ petitioner was to the effect that acting on OM dated 18/1/2023 issued by the Government of Assam in the Department of Personnel, the seniority position of his seniority position has been abruptly downgraded, thereby taking him out of the purview of zone of selection of the post of chief engineer full stop. Since the writ petitioner is holding the post of additional chief engineer bracket civil bracket close in the Department of Water Resources. Hence, according to the petitioner's counsel, his client was entitled to be considered for promotion to the post of chief engineer, Water Resources Department. Full stop. It was on the basis of such submission and by taking note of the request made by the learned departmental counsel seeking time to obtain instruction that this court had passed the interim order as noted above, full stop. By filing this IA, the applicant has urged that the DPC had met on 25/1/2023 under the chairmanship of the Chief Secretary of the Government of Assam and considered the candidature of as many as 4 officers in the rank,
3 officers.
3 officers
Three.
in the rank of additional chief engineer, which includes the writ petitioner and the two private respondents, which includes the writ petitioner, comma, the applicant and the opposite party number 7, full stop. Since the Mr. Goswami's learned counsel for the applicant submits that since the criteria for promotion is solely on merit, within quotes, merit, and considering the fact that all the 3 candidates, including the writ petitioner, have been considered for promotion, there is no justifiable ground to continue with the interim order at this stage, full stop. The learned counsel for the applicant has also pressed for vacation of the interim order by contending that his client is due for superannuation, due for retirement on attaining the age of superannuation with effect from 31/1/2023, and therefore, if the interim order is not vacated, irreparable injury will be caused to the applicant in the event he emerges as the selected candidate on merit. Full stop. Mr. D. Majumdar, learned Additional Advocate General, Assam, has also supported the contention of the applicant's counsel and has confirmed that all the 3 candidates, including the applicant and the writ petitioner, have been considered by the DPC and that the criteria for promotion is only merit, full stop. Next para. Mr. Das, learned counsel for the writ petitioner stroke OP number 8, has, however, strongly opposed the prayer made in the IA by submitting that at this stage, his client is unaware of the nature of proceedings before the DPC and therefore is not in a position to respond to the submissions made by the applicant's counsel. First up, according to Mr. Das, the perusal of the minutes of the DPC will only be sufficient basis for his client to figure out the nature of consideration made in this case, and therefore the interim order need not be vacated at this stage. First up, Mr. Das has, however, not denied or disputed the fact that the criteria for promotion is merit and that the applicant is retiring from service on 31/1/2023. Full stop. I have heard the submissions advanced by learned counsel for both these sides and have also gone through the materials available on record. Full stop. As noted above, the interim order dated 25/1/2023 was passed by this court purely on account of the fact that the learned departmental counsel had sought time to obtain instruction, and the petitioner's counsel and the counsel for the writ petitioner had urged that the DPC is likely to be held during the course of the day. First up, however, today, when the matter is called up, this court has been appraised that even the writ petitioner has been considered and the criteria for promotion is merit. First up, this court finds sufficient force in the submission of Mr. Majumdar that the petitioner, having been considered along with the other eligible candidates, the impugned OM dated 18/1/2023 would not have any relevant bearing in this case or the writ petitioner. Full stop. This court is also conscious of the fact that one of the eligible candidates, namely the applicant, is due for retirement with effect from 31/1/2023. Full stop. Therefore, there can be no doubt about the fact that if the interim order is continued at this stage, there is a strong possibility that same might result into irreparable injury to the interest of the applicant. First up, situated thus and considering the overall facts and circumstances of the case, this court is persuaded to pass an order modifying the interim order dated 25/1/2023. First up, it is hereby provided that the department would now be at liberty to notify the promotion of the selected candidate to the post of Chief Engineer, Water Resources Department, which would, however, be subject to further order that may be passed in this case. The learned departmental council is also directed to produce the records of the selection process on the next date fixed in the writ petition, that is 1/2/2023. With the above observation, the order dated 25/1/2023 stands modified. I stands disposal.
One thing, there is a submission made by my learned friend that on what basis he has not seen the minutes. So regarding my contention, that has been not considered.
Which contention?
He has not seen the minutes, whether what was the criteria. So can I not have a copy of the on
No,
Monday?
they have to produce it on first of February.
But your lordship has now once given them the liberty to notify. Then on the first, if they place the copy, he'll be retiring. Then suppose I find in the minutes.
He'll be retiring, he is gone. You can't do anything. A person who is retired, what can you do about it?
Means your
And why
lordship-
should you do something about it?
No, that I know, lordship.
just
Then I
one-
leave it to you, lordship.
And one submission.
Since it's
See, you are trying to enforce your client's fundamental rights, right?
because I need to know, figure out,
Yes.
lordship has written it. Then why, whether I'm there or not, is that I might be there, he might. Be
So
there.
maybe the consideration will be erroneous. Maybe the consideration will be correct. We can't presume that they will do something to cause injury to someone.
But the manner in which the matter has gone, the petitioner applicant basically knows everything about the minutes. It was he who came and said that I'm there. So
Whether
that-
one,
That I think
Mr.
that on
Das-
Monday he'll get the last day. As
But
a chief.
Let us rise above individual clients and their quabbles and wrangles. Let's not get into that. We are all
Yes.
members of a dignified profession.
We
Let's.
are.
one submission if your lordship records myself. There are only 3 persons in the feeder cater. All of them are even otherwise coming within the zone of consent. Very, very important.
At this light, Mr. Majumdar further submits that
There are only 3
there
persons.
are only 3 persons
Yes.
in the feeder cadre,
And-
including the applicant and the
Yes,
writ petitioner.
Even
And-
otherwise, all of
And
them. come within the-
regardless of the OM dated
Yes.
18/1/2023, all of them would be in the zone of consideration for filling up the post of Chief Engineer, Water Resources Department. Mr.
In fact, this was
Mr.
the
Das,
way-
you may have to draft the second petition, third petition rather, and that's good news.
Good for him, madam.
Can you stop the
in
live
a very
stream?
short period.